proceed to your seats. Will the members please rise for the invocation delivered by Dr. Jeff Eaton, Hope Community Church of Frankfort, Kentucky, and remain standing for the Pledge of Allegiance.
Thanks for your service. Please be safe going home. Let's pray together. Father, we're here by your grace. We say that often. I hope that we mean that deeply. It is by your grace. And your word tells us that your grace keeps giving to us. It's grace upon grace. Your word says that your grace overflows and that it has power. It's sufficient for anything that we're going through. And today, Lord, there are grieving families among us. And we know that you're bestowing your grace upon them. We rest in that. It brings us peace that your grace is being bestowed there. Bestow your grace upon all of us here this day, Lord, and even remind us that it's you that we get it from. It's not we ourselves. It's in the name of Jesus that I pray. Amen.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Bless you, sir, too. Clerk will sound the chimes. Members indicate your presence. Clerk will take the roll. Being 90 members indicating their presence, a quorum is declared and the House is ready to proceed. Next order of business, the excuse of absent members. Gentleman from Taylor.
Mr. Speaker, I move you, sir, that the absent members be excused in accordance with the House rules.
Without objection, so ordered. Gentleman from Taylor.
Mr. Speaker, I move to suspend the rules for the purpose of allowing members to co-sponsor bills and resolutions or to submit vote modifications and have filed the proper papers with the clerk to do so.
Without objection, so ordered. Next order of business, the approval of the journal. Lady from Davis.
Mr. Speaker, I move that the journal from Thursday, March 19th, 2026 be approved.
Without objection, the journal from Thursday, March 19th, 2026 is approved. Next order of business is second reading of bills. Clerk, please report.
Senate Bill 8 with House Committee Substitute 1 and House Floor Amendment 1, Senator Smith, an act relating to public utilities and declaring an emergency. Senate Bill 19, Senator Madden, an act relating to mushrooms. Senate Bill 29 with House Committee Substitute 1, Senator Elkins, an act relating to solid waste management facilities. Senate Bill 49 with House Committee Amendment 1, Senator Elkins, an act relating to battery stewardship. Senate Bill 56, Representative Neal, an act relating, or rather Senator Neal, an act relating to utilization contracts or controls for non-opioid analgesics in the Medicaid program. Senate Bill 70, Senator Higdon, an act relating to the Public Pension Oversight Board. Senate Bill 85, Senator Webb, an act relating to designating a special needs trust to receive state-administered retirement benefits. Senate Bill 100 with House Committee Substitute 1, Senator Mills, an act relating to the Energy Planning and Inventory Commission and declaring an emergency. Senate Bill 116 with House Floor Amendment 1, Senator Madden, an act relating to physician assistants. Senate Bill 122, Senator Rocky Adams, an act relating to alternative sentences. Senate Bill 129, Senator Nemes, an act relating to unemployment insurance. Senate Bill 137, Senator Meredith, an act relating to a provisional license to practice medicine. Senate Bill 147, Senator Richardson, an act relating to vital records. Senate Bill 222, Senator Herron, an act relating to environmental covenants and declaring an emergency. Senate Bill 226, Senator Elkins, an act relating to pre-need burial contracts. Senate Bill 343, Senator Wheeler, an act relating to the Department of Workers' Claims and declaring an emergency. And Senate Joint Resolution 54, Senator Chambers Armstrong, a joint resolution directing the Department of Libraries and Archives and the Cabinet for Health and Family Services to cooperate in exploring ways to increase enrollment in Dolly Parton's Imagination Library program.
Thank you, Mr. Clerk. Next order of business, report of committees. Please report.
The State Government Committee has met and reports House Bill 283 should pass to rules with House Committee Substitute 1 and House Committee Amendment 1, the title amendment, an act relating to foreign transactions in the Commonwealth.
Thank you, Mr. Clerk. House Bill 283, having received a previous reading, shall be considered as having its second reading and ordered in the possession of the Rules Committee for further action. Next order of business, the orders of the day. Lady from Davis.
Mr. Speaker, upon recess, the majority caucus will caucus in the temporary caucus room. So upon recess, we will caucus in the temporary caucus room.
Members take note. Lady from Davis.
Mr. Speaker, we need to recess to the call of the chair.
Without objection, the House will stand in recess to the call of the chair.
House come to order. Chair recognizes the gentleman from Bullitt, the chair of the Enrollment Committee, for an Enrollment Committee report.
Thank you, Mr. Speaker. The Enrollment Committee has met and found the following bills to be in order and ready for your signature. Senate Bills 40 and Senate Bill 11.
Thank you, Mr. Chairman. Chair is about to sign Senate Bill 40. Chair is about to sign Senate Bill 11. Thank you. We are in the orders of the day. Lady from Davis.
Thank you, Mr. Speaker. Mr. Speaker, I move that House Resolution 124 be taken from the Committee on Committees and placed in the orders of the day.
Without objection, so ordered. Lady from Davis.
Mr. Speaker, I move that House Resolution 124 be taken from the orders of the day, read by title and sponsor only, and placed upon its passage.
Motion's made and seconded that House Resolution 124 be taken from its place in the orders of the day, read for the third time by title and sponsor only, and placed upon its passage. Clerk, please report.
House Resolution 124, a resolution laying before the House of Representatives articles of impeachment against Julie Muth Goodman, Circuit Judge for the 22nd Judicial Circuit consisting of Fayette County. Representative Nemes.
Lady from Davis.
Mr. Speaker, I yield to the gentleman from Jefferson 33 for explanation of the resolution and motions thereon.
Chair recognizes the gentleman from Jefferson 33 for explanation of the resolution and a motion thereon.
Thank you, Mr. Speaker and members of the House. I rise today to report the findings and the recommendation of the House Impeachment Committee in the matter of Circuit Judge Julie Goodman. As you know, the Impeachment Committee voted to proceed with the articles of impeachment, and those are attached to the resolution today. Before I say a single word about Judge Goodman, I want to say something about this moment. Mr. Speaker, I do not want to be here. I mean that in every sense. I began my legal career as a law clerk for the Kentucky Supreme Court. I served as the Chief of Staff and the General Counsel to the Office of the Chief Justice. I served as the Director of the Administrative Office of the Courts. And I, like many others in this body, have spent my adult life in and around the courts of this state. I believe in those courts. I believe in the independence of the judiciary. And I believe that judges must be able to make hard, unpopular rulings without looking over their shoulder at this chamber. And I know that the impeachment power, if misused, is a danger to that independence. So I want to be clear. I'm the last person who wants to stand here and make this motion, but I will make it with a heavy heart, but with absolute confidence that it is right and that it is just. Mr. Speaker, well, let me tell you where I'm going with my remarks today so that members can follow along easily. First, I'm going to tell you what this proceeding is not. Second, I'm going to tell you what this proceeding is and what a misdemeanor in office means in the Constitution. Third, I will read the 5 articles of impeachment that are submitted to this body. Fourth, I will walk through 6 cases briefly, but with enough detail to understand why each one matters. Fifth, I will tell you about the testimony of Fayette Commons Attorney Kim Baird, which no appellate opinion can capture. And sixth, and finally, I will close with what I believe the totality of this evidence shows and demands. Let's begin. Members of the House, let me tell you what this proceeding is not, because I think this might be my most important words today. Judges get reversed. This is not a proceeding to impeach a judge for being reversed. Every week in the Commonwealth, appellate courts overturn trial court rulings. In the history of Kentucky's courts, there have been thousands upon thousands of reversals. The judges who were reversed in those cases were not brought before this body. They were not impeached. They went back to their courtrooms, continued their work, and most of them served with distinction. Reversal is not impeachment. Reversal is the system working exactly as it was designed to work. And what I want every judge in this Commonwealth, every judge watching the proceedings on television or who might read about it in a newspaper, what I want those judges to hear, I want them to hear this directly. You need not fear impeachment for doing your job to the best of your ability. A judge who wrestles honestly with a hard question, applies the law as she understands it, and gets reversed has done nothing wrong. That is judging, and judging is hard. Getting it wrong sometimes is part of the job. This body will never, and should never, make a judge's reversal rate the basis of an impeachment proceeding. What makes this case different is not that Judge Goodman was wrong. It was not even that she was wrong repeatedly. It is that the record before us, before this body, establishes in case after case that she was not simply wrong, she was intentionally wrong. She knew what the law required. She knew she lacked legal authority to do what she was doing, yet she proceeded and did it anyway. That is not a judge who made a mistake. That is something else entirely, and that is what this proceeding is about. Mr. Speaker, I will now turn to the law, specifically what misdemeanor in office means. Section 68 of the Constitution provides that civil officers of the Commonwealth, and judges or civil officers, shall be liable to impeachment for misdemeanors in office. The phrase misdemeanor in office does not mean what the word misdemeanor means in everyday criminal proceedings. It is not a petty crime or a crime of any sort. The phrase comes from the English common law tradition, was carried into American constitutional practice at our founding, and has a well-established meaning that encompasses far more than criminal conduct. In 2021, the Impeachment Committee sought guidance on this standard from a panel of advisors composed of former justices of the Kentucky Supreme Court, including one former Chief Justice, and 2 law professors who teach constitutional law. That was former Chief Justice Joseph Lambert, Justice William Graves, Justice Daniel Venters, Professor Sam Markison, and Professor Luke Milligan. And what did they conclude? They wrote, while the reference to misdemeanors in office might suggest that an actual criminal offense is required, it is apparent that in historical context, this phrase and its counterpart in the United States Constitution was not meant to only make criminal conduct impeachable. They concluded, the conduct that constitutes a misdemeanor in office, giving rise to impeachment, is that which involves illegal conduct, defiance of the rule of law, corruption, or neglect of duty. And they wrote, misdemeanor in office is synonymous with misconduct in office and is broad enough to embrace any willful malfeasance, misfeasance, or nonfeasance in office. Let me be precise about what those terms mean. Malfeasance is the affirmative commission of a wrongful act, or doing something you have no legal right to do. Misfeasance is the improper performance of a lawful act, but doing something within your authority, but doing it unlawfully. Nonfeasance is the failure to perform a required duty. And the standard is willfulness, not mistake, not error, willfulness. Knowing what the law requires and choosing not to follow it. And while this House is not governed or not bound by the court's own internal standards, the Kentucky Supreme Court has confirmed this standard in context of judicial discipline. In Gormley versus the Judicial Conduct Commission, the court held that a judge may be sanctioned for acting in bad faith, for engaging in a pattern of misconduct, and for a legal ruling or action made contrary to clear and determined law about which there is no confusion or question as to its interpretation. Our own Supreme Court has said, even one egregious bad faith incident of judicial misconduct may properly subject the judge to discipline, even removal. The standard the impeachment committee applied is that standard, not reversal, but willful misconduct. Now let me move to the articles of impeachment before this body. The committee presents articles of impeachment against Judge Goodman, 5 articles. Article 1 charges that during her term of office, Judge Goodman abused the power of her office she holds. Article 2 charges that during her term of office, Judge Goodman abused the powers of Judge Goodman defied binding precedents established by the highest courts of this Commonwealth. Article 3 charges that during her term of office, Judge Goodman defied statutes enacted by the General Assembly and defied rules of the Court of Justice. Article 4 charges that during her term of office, Judge Goodman interfered with the rights and powers of the grand jury, trial court jurors, attorneys, and others to perform their respective roles within the Court of Justice. Article 5 is a cumulative article, presenting all of the foregoing conduct collectively as a sustained pattern of willful misconduct in office that constitutes misdemeanors in office warranting impeachment and removal under Section 68 of the Constitution. Each of the first 4 articles is supported by multiple cases. I will now walk through 6 of those cases. Mr. Speaker, I'm going to give you enough detail in each case to understand why it matters to this proceeding. I will not read every Court of Appeals opinion into the record, and you have the committee's report for a much more detailed analysis. But I want you to understand the facts well enough to evaluate the evidence. Case 1, Commonwealth versus Jones. Dominic Jones was arrested with 75 grams of fentanyl, enough, according to toxicologists, to kill approximately 37,500 Kentuckians, and 11 grams of cocaine. He pleaded guilty to a Class C felony of fentanyl trafficking. The Commonwealth recommended 5 years imprisonment. KRS 218A-1412, a statute enacted by this body, states plainly that a person convicted of a Class C felony or higher involving fentanyl shall not be released on probation until serving at least 50% of the sentence. That is not a judgment call. That is a prohibition. Shall not. Judge Goodman sentenced Mr. Jones to 5 years, probated for 2 years to complete drug court. When the Commonwealth moved to correct the illegal sentence, she did not rule on the motion. She urged the parties to find a workaround, and she delayed for months. Then on March 8, 2024, she was informed that Jones had sued her. She announced she would recuse, but before recusing, she said these words, and I want you to hear them because they are key to this entire case. She said on the record that entering the judgment, quote, would be held to be void because I couldn't do it as a matter of law, close quote. She knew it was illegal. She said so out loud and in court. And then she signed it anyway, backdated it 3 months, and recused. The Court of Appeals vacated the judgment unanimously. This case supports Articles 1 and 3. It is not a judge who was wrong. It is a judge who told us she knew that she was wrong, then acted anyway. This is willful malfeasance, and it is the clearest possible example of it. Case 2, Commonwealth versus Thomas. I want to say a word before I describe this case. Doug Botkin came before the committee, the husband of the decedent. He testified that when his family went to court, they thought it was a plea hearing. Instead, they watched a judge dismiss the murder indictment against the man who killed his wife, Tammy. I was dumbfounded, he told us. And the family immediately asked me, what just happened? He described what followed as a painfully long 2-year process before the Court of Appeals reinstated the charges in December 2025 in perhaps the most extraordinary opinion I have ever read describing a judge's conduct. Here are the facts. On July 3rd, 2020, Cornell Thomas drove his vehicle 96 miles an hour, ran a red light, and struck Tammy Botkin's car. The collision severed her body. Thomas fled on foot. A Fayette County grand jury indicted Thomas for murder. Judge Goodman dismissed the indictment over the objection of the prosecutor on 3 grounds: lack of evidence of Thomas's sanity, prosecutorial misconduct, and selective prosecution. The defendant raised only the first ground. Judge Goodman invented the second and third herself, conducted a secret investigation during the hearing without telling the Commonwealth what she was doing, and the Commonwealth first found out it was on trial when it read the written order. The Court of Appeals reversed unanimously in a staggering 107-page opinion. That court said the order was fraught with legal errors and abuses. It said the fallacies the trial court embraces are legion. It said the trial court had a basic misapprehension of the trial judge's role in the justice system. It said the court failed to stay in its lane and improperly invaded the separate provinces of an independent grand jury, the executive branch prosecutor, and the petit jury. It said the court conducted a judicial ambush. It said the conduct reflects poorly on the judiciary as a whole, and after surveying more than 20 years of selective prosecution claims in Fayette County, the court wrote, absent any reasonable explanation, it would appear the trial court embraces animus of unknown origin toward the Fayette Commonwealth's attorney. That language, judicial ambush and animus of unknown origin, comes not from a prosecutor, not from the committee, and not from a politician. It comes from 3 judges on the Court of Appeals who reviewed this record and found no rational explanation. Critically, the court also noted that Judge Goodman effectively admitted she had been conducting her own independent extrajudicial research into prosecution's charging decisions. The court stated that her observations, based on a 15-year tenure, amounted to an inadmissible brand of judicial testimony, unsworn, untested by cross-examination, and in violation of the best evidence rule. And, it went on to write, it is difficult to imagine that this trial judge is capable of an unbiased adjudication of the Commonwealth's prosecution. Sua sponte recusal appears to be the only reasonable and appropriate solution, it said. This case supports Articles 1, 2, 3, and 4, and that description is just a very small amount of the opinion I invite everyone to read. This case supports all 4 substantive articles. Case 3, Commonwealth versus Hendren. James Hendren shot and killed his 23-year-old son. He claimed self-defense. A Fayette County jury heard 4 days of evidence, deliberated, and returned a unanimous verdict, guilty for murder. The jury recommended life imprisonment. Judge Goodman set aside that verdict and ordered a new trial, finding prosecutorial misconduct in the Commonwealth's closing argument and witness examination. The Court of Appeals, again, reversed unanimously on June 13, 2025, and ordered the jury verdict reinstated. It reviewed every ground Judge Goodman cited for misconduct and flatly rejected them all. The court said Judge Goodman failed to cite any case law supporting even one of her central grounds for misconduct. It described her approach as, quote, a Monday morning quarterback approach that contradicts our well-established precedent. The court concluded the circuit court not only ignored the law on this matter, but also impermissibly encroached on the province of the jury as finder of fact when she engaged in an independent review of the case in contravention of our jury system. I note for members that the Kentucky Supreme Court has granted discretionary review in this case. The committee has noted this in its report. The judge's grant of review is a routine matter and does not change the facts before this body, which are based on the Court of Appeals' unanimous findings of Judge Goodman's improper conduct, not the ruling on the law. This case supports Articles 2 and 4. Case 4 of 6, Simpson versus Cottle. Gregory Simpson was serving a 42-year aggregate sentence at Blackburn Correctional Complex. He filed a habeas corpus petition, arguing that the proper calculation of his sentence entitled him to immediate release. On January 18, 2024, Judge Goodman granted the petition and ordered his immediate release. The Court of Appeals, again, reversed unanimously on June 13, 2025. It found that Judge Goodman had misread the controlling statutes and the binding precedent of Blackburn versus Commonwealth. Simpson was to return to custody. But here is what makes this case significant for this proceeding beyond reversal itself. After the Court of Appeals reversed her, after the Court of Appeals entered its order, Judge Goodman granted Simpson's motion to stay her own compliance with the appellate court's order, effectively attempting to nullify the reversal and keep him free. The Court of Appeals had then again issue an extraordinary writ compelling her obedience with the previous order. The committee found that improperly granting that stay, requiring the Court of Appeals to issue an extraordinary writ to compel a circuit court judge's compliance with its own order, constitutes an abuse of office. This case supports Articles 1, 2, and 3. Case 5, Huff versus the University of Kentucky. Caitlin Huff received treatment at UK's medical center in 2022 and was determined to be permanently paralyzed. She and her husband sued UK for medical negligence. UK moved to dismiss based on governmental immunity. The controlling authority in that case is Withers versus University of Kentucky, a 1997 majority opinion of the Kentucky Supreme Court. 4 justices in the majority, not a plurality as Judge Goodman wrongfully alleged. And that court held the UK enjoys governmental immunity from medical negligence claims. That well-known holding has been affirmed in more than 50 subsequent opinions of the Court of Appeals and the Supreme Court since 1997. Every other Fayette Circuit Court judge and every circuit judge across the entire Commonwealth has to follow that law. Yet Judge Goodman denied UK's motion. She announced in open court, in words she placed on the record, that she was biting the bullet and deliberately choosing not to follow binding precedent, comparing herself to the courts that refused to follow Roe versus Wade. That analogy is factually wrong, and the record should reflect it. The courts in the Dobbs chain, the Southern District of Mississippi and the Fifth Circuit, both federal courts, did not defy binding precedent. They applied Roe faithfully, struck down Mississippi's law, and ruled against the state. The United States Supreme Court then changed the law on its own authority. No court in that chain ignored binding precedent to force the issue. So Judge Goodman's analogy misunderstands its own example. The Court of Appeals, once again, unanimously reversed Judge Goodman. It noted that while lower courts may express disagreement with the current state of the law, a circuit court abuses its discretion when it fails to follow applicable precedent. The proper approach is to follow the precedent, apply it, and invite a higher court to reconsider it. She did not do that. And at the time of the reversal, she had made the same ruling again in a second pending case. The Supreme Court has granted discretionary review, and the briefs have been submitted. Again, this is noted in the report. But the discretionary review does not change the issue before this body, which is not whether Judge Goodman got the law right or wrong, but whether she knew what the law required and she deliberately disobeyed it. This case supports Articles 2 and 3. Case 6. Ine versus University of Kentucky. Dr. Kenneth Ine was an endocrinologist at UK who was temporarily reassigned from clinical duties while a peer review investigation was conducted. He sued UK and several of its employees and administrators. During the litigation, Judge Goodman's conduct toward the defense prompted multiple parties to seek her recusal. The committee report sets out the full details of this case, but I want to highlight 2 specific moments for our members. First, at a January 12, 2024 hearing, when the University Outside Counsel respectfully disagreed with the court's characterization of the university's conduct, Judge Goodman said the university was so desperate to get rid of this doctor that they'd do anything at all costs, even potentially jeopardize the well-being of these patients who are fighting horrific cancer. And she reminded counsel of sanctions she had not yet imposed, saying in her threat, "I could have sanctioned you all last week. I could have held it up, taken the position that you turned everything over, and fined you $1,000 an hour until you did." But she didn't do those things, she says. The second and most important fact, at the April 5th, 2024 hearing, she stated on the record, "This court, unfortunately, feels like it has to be the sole protector of this doctor." The judge, the sole protector of a party. That's not her role. She thought she had to be the sole protector based on the continued attacks of Dr. Ine's character, his reputation, on his patients. Recusal motions, as I said, were filed. They followed, and she denied all the recusal motions directed to her. So the law allows a very rarely used procedure when you can take that question to the Chief Justice to disqualify a circuit judge. UK's counsel did that here. And Deputy Chief Justice Robert Conley stepped in, reviewed the record, and ordered Judge Goodman disqualified on February 14, 2025. He found her statements of being the sole protector impossible to ignore and concluded that a lay observer could reasonably question partiality towards the plaintiff and lack of impartiality against the defendants, and he disqualified her from the case. The report also documents that throughout the Ine litigation, Judge Goodman raised sua sponte, without any motion by any party, concerns about conflict of interest on the part of the UK's Defence Counsel, discussed whether they should be required to withdraw, and threatened criminal referral to the Commonwealth's attorney based on speculation from plaintiff's counsel alone, despite affidavits from the university's attorneys establishing that no misconduct had occurred. This case supports Articles 1, 3, and 4. Mr. Speaker, that was an explanation of the cases, and I know it maybe was a little bit in-depth, but I want you now to listen closely to what I'm about to say. I want to turn to a witness whose testimony the committee took seriously and whose credibility, I believe, is beyond question. Kimberly Baird is the Fayette Commonwealth's attorney. She was born and raised in Lexington. She graduated from the University of Kentucky and the UK College of Law. In January 1996, she began as an intern in the Fayette Commonwealth Attorney's Office under Ray Larson. She never left. She rose to first assistant in 2022. She was appointed the Commonwealth Attorney by Governor Beshear and was subsequently elected to that office by the people of Fayette County. She spent 30 years prosecuting cases in Fayette County courts. I want to note that contrary to the attacks against Ms. Baird, she did not file the impeachment petition or participate in it in any way. Neither did she initiate contact with the committee. To the contrary, the committee reached out to her and asked for her comments. She could have declined. She could have provided information quietly, behind the scenes, while staying out of the public eye. Instead, she submitted a detailed written letter with nearly 400 pages of supporting documents, and then she appeared under oath in front of the cameras before the committee in person. Mr. Speaker, that took courage. And I want this body and everyone to understand what she put on the line to be here. By appearing publicly and calling for the impeachment of a sitting judge, she put her professional reputation and reasonably questioned the professional reputation and perhaps her ability to practice in that courthouse at risk. She did it anyway, out of a sense of duty, because she believed the public interest required it. And she began her testimony with something very important. She told the committee that there are 4 other Fayette Circuit Court judges who rule against her regularly, and she was not here to testify against them. This was not about losing cases. This was about something different. Here is what she told us that was different. She said that Judge Goodman oversteps, this is her words, oversteps in leaps and bounds the separation of powers between the judiciary and the executive branch, especially my office, she said. She said her testimony was not about disagreement over a specific ruling, but about a full, comprehensive look at her disregard for precedent, established case law, and statutes in an effort to impose her personal will on a case. In an effort to impose her personal will on a case. That was her words, Ms. Baird's. Ms. Baird testified that Judge Goodman treats victims of crime with disrespect. Under Marcy's law, the constitutional amendment, and statutes protecting crimes victims' rights, victims have the right to be heard, to be present, and to have their safety considered. The people of Kentucky enshrine those rights in our Constitution, yet Ms. Baird testified that Judge Goodman has repeatedly told her office it was not supposed to present victim safety information to the court, that she did not want to hear from officers about the danger posed by defendants, and sometimes not even the victim and their legitimate safety concerns. She testified that when her office presented the victim's wishes regarding resolution of a case, Judge Goodman told her it ruins our credibility and that her office doesn't understand its role as the Commonwealth Attorney. The judge was, of course, wildly incorrect about the rights of victims in this Commonwealth, and they are in our Constitution. Ms. Baird also testified about restitution, the legal right of crime victims to be made whole. She said that even when a defendant agrees to a restitution amount, Judge Goodman will extensively question the restitution and sometimes require victims to appear in court to personally explain how a defendant is responsible after an agreement has been made. She said Judge Goodman has regularly stated that she has an issue with ordering restitution calling the process a mess, and has suggested that victims and businesses should sue defendants civilly rather than seek restitution through the criminal process. That is not what the law provides, and it is not the judge's role to say so. And then she told us something that no appellate opinion could ever document. Ms. Baird said, and I quote, "We have to deal with cases much differently in Judge Goodman's division than in the other 4 Fayette Circuit Court judges' courtrooms. We have to talk to victims about what to expect from her and any ruling that may come up, which will usually be against us. And we try to resolve those cases to take away as many rulings from her as we can." Listen closely to that. The elected prosecutor of Fayette County has to prepare victims for what to expect in one specific courtroom, because what happens there is predictably hostile to the prosecution and to the victims, to the Kentuckians that she represents. She structures her cases, Ms. Baird structures her cases to avoid putting decisions in that judge's hands. She resolves cases through plea agreements and mediation differently, not because those are the right outcomes, but to minimize exposure to that one judge. That is not a prosecutor who loses cases sometimes. That is a prosecutor who has permanently changed how she does her job for every case, for every victim, because one judge's conduct has made her courtroom an unreliable forum for the fair administration of justice. And as context, not as an independent argument for impeachment, Ms. Baird provided data showing that Judge Goodman since she joined the bench in 2019, defendants' success rates on suppression motions in her division has been a jaw-dropping 80%. The other 4 Fayette Circuit Court judges ranged from 12% to 32% over the same period. I'm not telling you that ruling for defendants on suppression motions is grounds for impeachment. I'm not saying that. What I am telling you is that this number is one more data point that confirms what every piece of evidence in this proceeding shows. Something has gone profoundly wrong in this one courtroom. When asked directly by the committee, Ms. Baird said, with evident reluctance, because she knows as well as anyone what it means to call for the impeachment of a judge, quote, "I think she has violated the trust that was instilled in her by the people who elected her," close quote. And she urged the House to impeach Judge Goodman. The committee took that seriously. We took it seriously because Ms. Baird knows more about what happens in Judge Goodman's courtroom than any other person who could appear before us. Her testimony is not the testimony of a partisan. It is the testimony of a career public servant trying to protect the people of Fayette County from the biased rulings of one judge who proudly considers herself, in her own words, an advocate. Members of the House, let me bring this together. You've heard 6 cases, and I want to synthesize what they show because the pattern is the point. In Jones, she imposed a sentence a statute of this General Assembly expressly prohibits, acknowledged on the record that she knew what she was doing. She knew what she was doing was wrong, and she did it anyway. In Thomas, she dismissed a murder indictment through what 3 appellate judges unanimously called a judicial ambush, secretly investigating claims no party raised, substituting her own racial justice conclusions for the grand jury's independent judgment, and acting out of what those same judges could only describe as an animus of unknown origin toward the prosecutor. And in doing so, she left a grieving family, Doug Botkin's family, waiting 2 years for justice that a grand jury had already granted. In Hendren, she set aside a jury's unanimous verdict by finding prosecutorial misconduct under no recognized legal standard, substituting her own post-verdict review for the trial jury's factual findings, and was reversed on every single ground she cited. In Simpson, she released a felon who had 21 more years to serve, and when the Court of Appeals reversed her, she attempted to stay her own compliance with the reversal, requiring the Court of Appeals to issue an extraordinary writ just to compel a circuit court to obey its ruling. In Huff, she publicly announced she was choosing to ignore more than 50 binding opinions of the Court of Appeals and the Kentucky Supreme Court, drew an analogy that was factually wrong, continuing making the same ruling after being reversed and was overturned unanimously. Finally, in Ein, she declared herself the sole protector of one party in a pending case, threatened criminal referral of a defense counsel based on speculation alone, refused recusal, and was disqualified by Deputy Chief Justice of the Kentucky Supreme Court. What is the through line? What is the pattern that connects these 6 cases across several years? It is this. Judge Goodman sees herself as a law unto herself. If she does not like a statute enacted by the General Assembly, she disregards it. If she disagrees with the binding precedent of the Court of Appeals or the Supreme Court, she announces she will not follow it. If she believes a prosecutor is acting improperly, she conducts her own investigation and renders her own verdict without notice, without authority, and without regard for the constitutional role of the grand jury or the petit jury. If she believes a party deserves her protection, she says so out loud from the bench on the record in terms that make her impartiality impossible to defend. The question before this body is not whether she was wrong. She was, repeatedly, dramatically. But the question is whether she was willfully wrong, whether she knew what the law required and refused to obey it. And the record answers that question. In Jones, she told us herself. In Huff, she told us herself. In Thomas, 3 appellate judges looked at the record and could find no rational explanation for what she did. In Hendren, the Court of Appeals found she applied no recognizable standard at all. In Simpson, she tried to nullify an appellate ruling. In Ein, a justice of the Kentucky Supreme Court said her words were impossible to ignore. The misdemeanor and office standard as defined by 3 former Kentucky Supreme Court justices, including 1 former Chief Justice, is met when a judge engages in willful malfeasance, willful defiance of the rule of law, or willful neglect of duty. The record before this committee establishes all 3 in multiple cases over multiple years, and it is important to note that this House is not voting to remove Judge Goodman from office. That is the work and the decision of the Senate. The question before us is whether there is enough evidence to present that case to the Senate. By way of analogy, we are the grand jury, determining whether there is enough evidence to move forward. Continuing that analogy, the Senate is the trial court determining whether to remove Judge Goodman. Members of the House, I want to close where I began. I do not want to be here. I love the courts of this Commonwealth. I've dedicated a significant part of my career to them. The courts work because people trust them. They trust them because judges follow the law, even when the law produces outcomes the judge would not choose. Even when the law seems unfair to a defendant, they feel sympathy for. Even when the judge believes the precedent is outdated or the statute is wrong. Following the law when you disagree with it is not weakness. It is the foundation of the rule of law. It is what separates a system of justice from personal preference. Judge Goodman was given the power of the bench by the people of Fayette County and by the Constitution of this Commonwealth. That power was not given to her to use as she sees fit. It was given to her in trust, to be exercised according to law, impartially, and within the boundaries of that the law establishes. Miss Baird said it best. She believes Judge Goodman has violated the trust that was instilled in her by the people who elected her. The impeachment committee agrees. Section 68 of the Constitution provides the remedy. The impeachment committee has done its work. Now the evidence is before you. I make this motion with a heavy heart, Mr. Speaker, but I make it with the absolute confidence that it is right and that it is just. Mr. Speaker, I move adoption of Resolution 124 of the Articles of Impeachment and the transmittal of those articles to the Senate of the Commonwealth for trial pursuant to Section 68 of the Constitution of Kentucky.
Motion is for the adoption of the Articles of Impeachment and the transmittal of those articles to the Senate of the Commonwealth for trial pursuant to Section 68 of the Constitution of Kentucky. Is there any discussion? Chair recognizes the lady from Jefferson 43 for discussion of the matter.
I too agree that we don't want to be here. We don't want to be here. And yet, we've been asked to recommend impeachment for a judge who's not following the rules, and we are not following our rules. Impeachment is an extraordinary constitutional remedy. It must be exercised with restraint and only upon clear showing of a misdemeanor, a crime, in office under Section 68 of the Kentucky Constitution. The standard has not been met here. Where is the crime? The petition is fatally defective because it does not comply with KRS 63.030, which requires that if you're going to offer an impeachment, a petition for impeachment, that it be verified by the affidavit and supported by sworn documents. The applicant did not swear to the facts and did not appear before the impeachment committee. Here, the petition contains no verified affidavit, no sworn factual declarations. The absence of an affidavit is not a technical defect. It is a threshold requirement. It is a rule we said people must follow if they want to offer an impeachment. Prior to the impeachment proceedings in Kentucky, such as in the 2021 impeachment of A.G. Cameron, we have recognized that petitions lacking affidavits may be summarily dismissed. So we are asked to ignore the statutory requirements in order to impeach a judge for failing to follow statutes. The second issue is due process. The absence of sworn allegations and identifiable accusers raises serious concerns under Section 11 of the Kentucky Constitution and the 5th and 14th Amendments to the United States Constitution. Due process requires notice and a meaningful opportunity to be heard, including the ability to know and confront one's accuser. These requirements of due process have not been satisfied. In the petition, identifies 6 cases that have been discussed as the basis for impeachment. The record reflects that 5 of the 6 cases are still under appeal. The judge could not defend herself because under the Kentucky Code of Judicial Conduct, judges are ethically prohibited from making any public statements that could affect the outcome of any case that's still open. As a result, she is ethically barred from speaking to those 5 cases, and this places her in an untenable position. Is she forced to choose between complying with the judicial ethics standards or fully defending herself in the hearing? Section 68 of the Constitution authorizes impeachment only for one thing only, and that is a misdemeanor in office. The petition and articles contain only assertions, no evidence, no proof, no documentation, no at 4 o'clock at this time I saw the judge take money. It contains no facts about anything that would constitute misconduct. It doesn't identify criminal misconduct, ethical violations, or the abuse of office rising to a constitutional level. Kentucky precedent indicates that impeachment has historically been reserved for serious misconduct, including criminal acts or an egregious abuse of authority, not disagreements over judicial decisions, not temperament. Only one judge in the history of Kentucky has been impeached. It was more than 200 years ago, and it was for treason. In 2021, the Impeachment Committee's report on Governor Beshear concluded the scarce use of impeachment in the Commonwealth further emphasizes that the process of impeachment was and still is intended to only address serious abuses by public officials, not disagreements about exercises of discretion in your official job. That is a direct quote from the opinion. These allegations arise from Judge Goodman's rulings in different cases, her interpretation of the law, management of proceedings. These are just core judicial functions. That's what judges do. They manage the cases, they interpret the law, and they manage the proceedings. The Kentucky Constitution provides a clear remedy for alleged legal error. Appellate review. She's been on the bench 6 years, 70,000 cases. They have an internal system to handle those type of situations. One is appellate review. The second is they have a judicial conduct commission that if you have a complaint against a judge, you complain to this judicial commission and they will investigate and determine whether or not there was a misdemeanor made. There was no complaints made to anybody in the JCC, the Judicial Conduct Commission, nor was there any complaints made to any higher up courts or the courts of administration or the Kentucky Bar. No one in 6 years filed a complaint. No one. And yet now we must recommend removing her because they didn't file a complaint, and we've come to this point. The absence of a complaint, to me, would indicate there's no independent finding of misconduct. A failure to utilize the appropriate process for addressing judicial behavior was ignored. All the administrative remedies were ignored. All the processes the judges and the Supreme Court have in place were ignored. And no one said or did anything for 5 or 6 years until now, when some person filed an unverified report to have her removed. It's very convenient. Additionally, the Kentucky Constitution establishes a clear separation of power among the legislative, executive, and judicial branches. Section 28 contains an unusually forceful command to specifically prohibit incursion of one branch of government into the powers and functions of the others. That's why we gave the judicial branch their own set of remedies and offices to handle judges' misconduct. Permitting impeachment based on judicial rulings would allow the legislator to review case outcomes. We're reviewing a case outcome. Secondly, it would undermine judicial independence because now the judges will be thinking, will this opinion cause the legislature to review my actions? It's a chilling effect. Then it would create a precedent for politically motivated removal efforts. Impeachment in these circumstances would be incompatible with the design of our Constitution. Impeachment of a sitting judge for conduct in an active case would have a chilling effect on the judiciary, and it would open the floodgates of disgruntled litigants and make sure that every judge is thinking 2, 3, 4 times before they do that for which they are charged. In conclusion, the petition is procedurally defective. The record lacks sworn evidence and due process safeguards. She could not defend herself. The articles fail to allege conduct constituting a misdemeanor, a crime in office. What is the misdemeanor exactly? The allegations improperly target judicial decision-making, and proceeding with impeachment would pose a serious threat to the separation of powers and put everyone in all 3 branches at risk for any politically motivated impeachment affidavit to be filed. I respectfully recommend that the House of Representatives vote no, that we respect the will of the people that have voted her in 6 times over and over and over again, that we respect the constitutional separation of powers, and that we respect the seriousness of the responsibilities which are entrusted to this body, and that we take no further action on the impeachment of Judge Julie Goodman until we have fulfilled the requirements and we have a crime, a misdemeanor before us. Thank you.
Chair recognizes the gentleman from Boyle for discussion of the matter.
Thank you, Mr. Speaker. May I speak on the resolution?
Yes, sir.
I want to first of all compliment my friend, the gentleman from Jefferson, for his work as chairman of the impeachment committee. That's a very difficult assignment, and I think that he performed that very well, very professionally. And the hearing that we had on Monday was conducted in a manner that all of us in this chamber can appreciate. It's not easy for me to be on the opposite side of my friend from Jefferson, but I do rise this morning to oppose the impeachment resolution. Mr. Speaker, I don't believe that when a judge fails to follow binding precedent that is impeachable conduct. And as you've heard this morning, that is much of what is in the articles of impeachment against Judge Goodman. When a judge doesn't follow binding precedent, that can be remedied on appeal. In this particular case, Judge Goodman hasn't committed any crime. And the only question in my mind as a ex officio member of the impeachment committee is whether she abused the powers of her office as a judge to improperly dictate the outcomes of criminal cases. And in my judgment, the conduct does not rise to the level of a misdemeanor to impeach. Judge Goodman has never been disciplined by the Supreme Court or the Judicial Conduct Commission in her 18 years as a judge. She's had 70,000 cases. We're talking about 6 of those, 5 of which are pending appellate review. I think it's pretty clear that Judge Goodman's conduct with the Fayette Commonwealth Attorney's Office has been unprofessional. And I think that our hearing bore that out. The Fayette County Commonwealth's attorney, she was very brave in coming before us to recommend impeachment. And I think that she had some frustrations that were warranted. Her frustrations were warranted. When you review the 6 cases that the gentleman from Jefferson has outlined this morning, there is a pattern of conduct that is unprofessional. And I think that Judge Goodman has failed to understand that. And I think that bore out in the hearing. And so I'm not here today to defend Judge Goodman's judicial decisions in these 6 cases or her treatment of the Fayette County Commonwealth Attorney's Office. But I was sympathetic to the fact that she was unable to discuss the cases that we're discussing this morning because 5 of the 6 are still on appeal. From what I can tell, Mr. Speaker, we've had 4 impeachments in our history, and most of those have been based upon a crime committed. They've also typically been unanimous, and this morning this isn't going to be unanimous. This is obviously there's going to be opposition to this. And so there's no historic precedent in the history of the Commonwealth that supports impeaching Judge Goodman for the reasons that have been outlined by my friend in the articles. And the precedent that would be set today is bad for the future. It sets a standard that many in our judiciary will question, and it seeks to overturn the will of the voters in Fayette County for reasons that have never been considered grounds for impeachment of a judge before. So we're setting a new standard this morning if we do this. So I would urge the members of this body to vote no, to oppose the articles of impeachment, and I thank the Speaker for the time.
Chair recognizes the gentleman from Boone 66 for discussion of the matter.
Will the sponsor yield to a question?
He will yield.
Sponsor, does the Kentucky Constitution require the filing of a petition for us to initiate impeachment proceedings?
Gentleman from Jefferson.
Thank you, Mr. Speaker. No, it does not. There are two ways to do it. The initial way that my friend from Jefferson was mentioned was a petition from a citizen. There was no affidavit. We're not operating under that statute. We don't have to operate under any statutes. It's a constitutional power. We're operating under a different statute, and the impeachment committee, the chairman, which is myself, and the vice chairman, which is the gentleman from McGoffin, have filed this resolution. So if there were any problems with its filing, not sure there were, but if there were, those have been addressed by the chairman and the vice chairman of the impeachment committee filing their own resolution of impeachment.
Gentleman from Boone.
Will the sponsor yield to another question?
He will yield.
Sponsor, does Section 109 of the Kentucky Constitution make clear that the impeachment powers of the General Assembly shall remain inviolate?
Gentleman from Jefferson.
Yes, that is their actual language. So Sections 66 through 68, which are the impeachment provisions, were provided in the 1890 Constitution. In the late 1970s, the people of Kentucky went back and rewrote the judicial article, establishing what we have now as the Court of Justice. And in Section 109, which was one of those provisions, the very last sentence of that provision, it says, the impeachment power shall remain, that which is before, remain inviolate. So while there is a Judicial Conduct Commission, and there was also a way to remove judges internally to the judiciary before, so while there is a Judicial Conduct Commission, this House's impeachment powers remain inviolate.
Gentleman from Boone.
And just another question for the sponsor.
He will yield.
I just want to be clear that Section 66 enables the House to initiate impeachment proceedings. But Section 68 of the Kentucky Constitution is what gives the Senate the power to determine guilt or innocence and whether to remove and render one ineligible for holding positions of public trust or profit in the Commonwealth. Is that correct?
Gentleman from Jefferson.
Thank you, Mr. Speaker. Yes, it is correct. What we're voting on today is whether to move it forward to the Senate. What the Senate will be voting on is two things. One, whether to remove Judge Goodman from office, and if so, then they have a separate question, and that is that they can prohibit her from running for office again or holding any office. They don't have to do that, but it's two separate questions. The first question is whether to remove her. That's not our decision, and not what we're talking about today. That's the Senate's question.
Gentleman from Boone.
May I speak on the resolution, Mr. Speaker?
Yes, sir.
The House of Representatives shall have the sole power of impeachment. That is the language not only of our state constitution, it is the language of the United States Constitution. It is a clearly defined term that we have adopted from the U.S. Constitution. I bring up the U.S. Constitution, Mr. Speaker, because one of our founding fathers, Alexander Hamilton, addressed the question of what constitutes a misdemeanor in office, because Article 2 of the U.S. Constitution brings up misdemeanors in office as well. His exact words were, "The subjects of its jurisdiction are those offenses which proceed from the misconduct of public men, or in other words, from the abuse or violation of some public trust." The statement from the three former justices of the Kentucky Supreme Court is not the first time that we have seen language that states that a misdemeanor in office is not necessarily a criminal offense. That's certainly the case. But also, breaches of the public trust, abuses of office, that is misconduct in office. Alexander Hamilton wrote extensively in the Federalist Papers, in Federalist 65, 66, and even 69 as well, indicating that this is an essential check on the branches to ensure that the rule of law is upheld. And this is what we are debating here, whether the breach of the rule of law was not only just a decision that a judge got wrong, that happens all the time, but whether this was an intentional knowledge of the law, but a decision to disregard it. And Mr. Speaker, I was astonished in the hearing when we heard Judge Goodman state that she would not change her rulings even today, that even with the corrections of the law, that she stands by these rulings, that she stated in open court she knew were not appropriate. Mr. Speaker, that is and abuse of public trust. And this is a serious consideration to take. This is not a decision any member should take lightly. And there is precedential concern. I sympathize with that. I believe in an independent judiciary, but I believe in an independent judiciary who is solely bound to the law of the Commonwealth and the laws set out in our state and our federal Constitution. I am terrified of the precedent of not moving forward with this impeachment. I am terrified of the message that would send. I'm terrified of how that would affect my community or the communities of anyone in this body or the communities of anyone in Kentucky. If we send a message to a judge that they can know the law, they can rule against the law simply because of their own personal value system. That is not the role of a judge. Mr. Speaker, I rise in support of this resolution with serious consideration. But my question, Mr. Speaker, is if this is not an impeachable offense, if knowingly disregarding the law is not an impeachable offense, what is? Thank you, Mr. Speaker.
Chair recognizes the gentleman from Jefferson 42 for discussion of the matter.
Thank you, Mr. Speaker. May I speak on the resolution?
Yes, sir.
Before I begin, Mr. Speaker, and I do intend to not belabor the points that were made today, but I do want to commend the gentleman from Jefferson and all the members of the impeachment committee for handling this very serious and solemn occasion with what I believe was a great deal of professionalism. This is very difficult, and I do not have the benefit of being legally trained, being a lawyer, like many lay people of the Commonwealth. And the gentleman from Jefferson allowed me many, many times to ask many questions that I'm certain gave him many headaches at night. But with that being said, as a member of the committee and as a member of this body, I have the responsibility to take in more information than the average Kentuckian, to sift through thousands of pages of documents and sit and listen to testimony that was given to the committee. And I also want to acknowledge the gravity of what the Commonwealth Attorney did, as well as the family. That's a hard thing to do. And I would imagine for the family, it is like reliving the entire event all over again. So it gives me no great pleasure to stand here and say that I too must rise in opposition to the resolution. And I'd like to begin with this statement that this is not about whether every member of this body agrees with every decision that Judge Goodman has ever made. I'm certain if I comb through almost 72,000 decisions that she's made in her career, I could find some that I personally disagreed with. Because reasonable people can disagree with judges. That happens every single day in Kentucky. My concern is a bit more basic than that. That concern is whether the House is following the right processes and using the right remedy and ultimately respecting the will of the people. That there have been procedural comments made about the process on either side of the argument, and I will not belabor those. I would point out that the minority report that was submitted does cite the fact that the petition does not meet the basic statutory requirements as set out in KRS 63030. I won't repeat that any further, but I believe that those statutory requirements matter. They matter because impeachment is not a routine motion. It's not simply another debate. It is one of the most serious actions this body can take. And I believe that every member here understands that. We are talking about removing a duly elected public official from office. And if we're going to do something that's serious, I believe the legal threshold should be clear, it should be disciplined, and it should be satisfied from the start. In this case, I don't believe that it is. Secondly, Mr. Speaker, I do believe that there are already remedies available when concerns arise about a judge. It has already been stated that there's opportunities for the Supreme Court to intervene. There's opportunities for the Judicial Conduct Commission to intervene. Those did not happen in this case. And that matters. If someone believes a judge made the wrong legal decision, then there are legal remedies in appellate courts as well. Some of those have been exhausted, and they've yielded different results. That is the system working as it was intended to do. Lastly, and probably most important, if the voters lose confidence in a judge, there is always, in my opinion, another remedy, and the highest remedy there is, and that is the ballot box. A judge has a record for everyone to see. And if the voters of Fayette County, who have repeatedly voted Judge Goodman in time and time again, have lost confidence, then those voters have a choice. And I believe those voters will make that decision. That decision, in my opinion, is not up to this body. And that's important, because impeachment is supposed to be the will of the people. It's not a first response. It's not a political response, as I do not believe this is. It is a last resort. And if we skip over those channels, Mr. Speaker, we move past procedure, past administrative review, past the appellate process, past the voters, then we are not strengthening the system. We are weakening it. Lastly, we should be very careful before we substitute our judgment for that of the voters. The people in the community have had the opportunity to evaluate the conduct, the service, and the record over time. And they have returned Judge Goodman to the bench. Now, let me be very clear. That does not mean that a judge cannot be impeached. It does not mean that a judge could never be impeached. Of course not. But it does mean that this House should be humbled and disciplined before overturning that will, because there's something bigger at stake. If the House delivers these articles, we are signaling to Kentuckians and frankly the rest of the country what we believe our standard is. And in my opinion, that standard is unclear. If I were to ask 10 people in this body to define the impeachable conduct in this case, I would be a betting man to believe that I would get 10 different answers. And I think that is the problem. Because if that standard is unclear today, then that lack of clarity becomes the standard for tomorrow. And once it becomes that standard, it then becomes the precedent. And this body's place in history would be unlike that of any other Kentucky House in more than 200 years. This moment today is going to be discussed in classrooms and law schools and in public life for many years to come. What we do here today will matter long after each and every one of us leaves this sacred institution. And how we leave this institution will matter to our children, to their children, and to their children. It will matter to people who we will never meet. That's how serious it is. Because if we put forth this standard as Kentucky, what does it mean for the stability of other institutions and other courts in the country? How would any other judge in any other court stand up to that level of scrutiny? From the circuit courts to the highest court in the land, the Supreme Court. If the misdemeanor is unclear, is that really the rule of thumb Kentucky wants to set? I do not believe it is. There have been many decisions, Mr. Speaker, in closing, that I have disagreed with from judges. Some locally, some statewide, some federally. many decisions that I've disagreed with. Millions of people have disagreed with. I have watched a judge, multiple judges in my lifetime, sit on the record and state that laws were settled case law and turned around and voted against them in my lifetime, completely disregarding precedent. And millions believe that was the wrong thing to do. Does that justify impeachment too? I suspect many of my friends on the other side would say no. I expect the gentleman from Jefferson to say no, and it is you all's right. That's why the standards matter, the clarity matter, and the restraint matters. Mr. Speaker, I believe that the House should reserve impeachment for the clearest, most serious, and most procedurally sound cases. This is not that case, and for those reasons, I respectfully vote no, encourage this honorable body to do the same. Thank you.
Chair recognizes the gentleman from Warren 17 for discussion on the matter.
Thank you, Mr. Speaker. Nothing is any more foundational to who we are as a nation than a fair judicial system. I was just in Washington, D.C., our nation's capital, and passed by the Supreme Court building and saw the blindfolded Lady Justice statue, which symbolizes neutrality and fairness. This is a charge to be impartial, regardless of feelings or personal bias. Our country's future depends upon that premise. The vote that I take today is the most important vote that I have taken as a legislator, and it could be the most important vote that I ever take. I am not happy, and I am not angry, but I am resolved to do the right thing. My decision to vote to impeach weighs heavy on me, but I must decide solely upon the evidence to protect our Commonwealth and our country. We have before us a judge who has lost her way. Make no mistake, we are accountable to someone, and that someone is the people of Kentucky. Today, we are their voice, and we must not abdicate that responsibility. In the evidence presented, we see a defiance of the rule of law where Judge Goodman acknowledged on record that the sentence she was entering was illegal, and then she entered it anyway. The Fayette Commonwealth's attorney said in her testimony that the cumulative effect of her behavior is a violation of the trust that the public instilled in her to rule competently according to the law. We must ask ourselves a simple question. Were these mistakes or were they willful acts? The overwhelming evidence before us today clearly demonstrated that she had an understanding of what was right and then a willful decision to do the exact opposite. In her testimony, Judge Goodman said that she would stand by her opinion, which means that nothing would change going forward. Our justice system demands a higher standard. It is with a heavy heart, but not uncertainty, that I will vote to impeach.
Chair recognizes the lady from Jefferson 41 for discussion on the matter.
Thank you, Mr. Speaker. I'd like to speak on the resolution.
Yes, ma'am.
Thank you, Mr. Speaker. So, here we are today on a Friday with a heavy heart. But this is wrong on so many levels. And the first level is the paperwork was so incorrect filing against this judge. There was no affidavit that was signed or notarized. The petitioner does not appear to be a resident or even a voter in Fayette County, and he has no documented connections to any of the 71,000 cases that has come before her in these 18 years. In fact, the petitioner was a failed candidate for state rep, and in fact is running again. So the paperwork is totally filed incorrectly, which should have been a reason to reject this case altogether. Because when candidates, even for state rep, file incorrectly, often folks in this body have taken them to court to remove them from the ballot. Incorrect paperwork from a person who has had no documented cases of the 71,000 cases this woman has presided over in her 18 years and been reelected 6 times, by the way. So my question is, why did this not go to the Judicial Conduct Committee if it's so egregious? Who knows? It's just frightening, with that. This just kind of feels a bit like a witch hunt, but maybe it's not. But impeaching a judge over perceived rulings, and there's 6, 5 of which are still under appeal, so she can't defend herself before the committee on those 5. But the committee can certainly find a lot of what they feel is egregious, but no defense can be offered because they're still on appeal. So she's going to this committee basically with both hands tied behind her back. But if we impeach a judge for rulings that we don't like or someone doesn't like, it'd be like impeaching us for votes that we take that someone doesn't like, for a bad vote. Is that the precedent we want to set? That because we voted bad, somebody could try to take us out? Or should we let that go to the ballot box and let our voters say, we don't like how you voted. We're voting for the opponent this time. This woman has had 71,000 cases, and we've pulled out 6 by a person who has had no documented cases with this woman. This would really set a precedent, and every judge in all 120 counties should be frightened and terrified that we're about to do this to a judge. All your judges that you know, all of our friends who are judges that have to rule on really terrifying and frightening cases that have to weigh the balance, as the gentleman said. But every judge in every 120 counties could be at risk if we set a precedent of this nature. Again, I ask, why didn't the petitioner go to the Judicial Conduct Committee, which is where this should be? Again, she did not commit a misdemeanor as it says in Section 68 of our Kentucky Constitution. There was no misdemeanor found. No crime committed in office. Yeah, she might have said things that we don't like or someone doesn't like. Evidently, the petitioner didn't like some of the things she said. But again, she couldn't defend herself because 5 of the 6 cases are still on appeal. And the Commonwealth attorney that came to testify, I just wonder if there were personal items going on back and forth. Who knows? But just because she testifies, to me, doesn't mean a whole lot, because there could be some contentious behavior between the 2 of them. You know, we don't like everybody in here doesn't like each other. But I like all of you. But everybody doesn't like each other. But that isn't any reason. And we don't know what the reasons are behind this testimony. Again, why isn't it at the Judicial Conduct Committee, or Commission, I'm sorry. Once again, she had over 71,000 cases in her 18 years of service to this Commonwealth. Cannot defend herself against these charges. And the petitioner filed the paperwork incorrectly. That's why I think that this is a witch hunt to go after this woman who has served and been reelected 6 times. Again, it sets a dangerous precedent for every judge out there who I bet is watching this today. And many of you know we have a hard time getting decent judges, good judges, to run for office. And this would put a chilling effect on trying to find good people to run. Because who knows who's next? And I would urge the body to think very carefully and reject this resolution and vote no on it. Thank you so much, Mr. Speaker.
Chair recognizes the lady from Jefferson 40 for discussion of the matter.
Thank you, Mr. Speaker. There have been a lot of points made today. Oh, apologies. May I speak on the resolution?
Yes, ma'am.
I don't want to belabor the points that have already been made, but I do want to reiterate some of the important nuances that have been brought up by my colleagues. We are today setting a dangerous precedent, and I agree with the gentleman from Boyle that it's a new standard. This is a brand new standard that we're setting today if we move forward with these articles of impeachment. As has been mentioned, impeachments in Kentucky have been exceedingly rare, and they're reserved only for extreme cases of misconduct. Extreme cases of misconduct. I served on the impeachment committee in 2023, where we voted unanimously to impeach a prosecutor who had engaged in egregious and criminal behavior. That gentleman has since been sentenced to 14 federal charges. That was the first impeachment that Kentucky had seen in a century. And it was unanimous, and there was criminal behavior involved. There's a reason that we use the power that we have to bring articles of impeachment with incredible restraint. We have used it 4 times, as it has been mentioned in the history of Kentucky before 2023. And the reason for that restraint is that this is a powerful authority. Judges are elected in Kentucky, just like we're elected. We're elected to make laws. Judges are elected to make rulings on civil and criminal cases. We don't do their job. They don't do our job. We can disagree all day long on the conduct of Judge Goodman. We can disagree with her rulings. We can disagree with all kinds of things, but that does not rise to the level needed to actually impeach a sitting judge who has been elected and re-elected by the voters in Kentucky for 18 years. We've talked a lot this session about the safety and the security of our elections. If we move forward with this resolution, we are acting in direct contravention of the will of Kentucky voters. And we, as this body, we become the reason that elections are not safe and secure. As the lady from Jefferson 41 mentioned, we are sending a message. We are sending a direct message, a clear message to every judge in every county in this Commonwealth that if we don't like the way you rule, if we don't like the way that you're conducting yourself, we will use that authority whenever and however we wish to impeach you, to bring articles of impeachment against you. So if we move forward with this resolution, we are acting against the will of the voters. And in a time when democracy, democratic institutions, democratic values are being eroded, we can see it happening nationally, we cannot continue with that behavior. We have to be beholden to our Constitution. We have to be beholden to the will of our voters. And we cannot continue with this resolution if we are acting in good faith as stewards of our democracy. Thank you.
Chair recognizes the lady from Shelby for discussion of the matter.
Thank you, Mr. Speaker. May I can discuss the matter.
You're recognized to do so.
Thank you. Mr. Speaker, I agree that this resolution is something none of us in this room ever wanted or expected to have before us. Serving on this impeachment committee has been by far the most painful duty probably anyone on the committee has ever been called to do. I do want to echo the words of the gentleman from Jefferson 42 that I have appreciated the serious and professional manner in which every member of this committee has met and discussed the evidence we reviewed and the decision we would make. Before I speak briefly about why I have painfully decided to vote yes on this resolution, I want to correct the record about an erroneous comment that has been made repeatedly by various people standing in opposition to the resolution, that being that the Judicial Conduct Commission has received no complaints against Judge Goodman and has issued no decisions against her. Mr. Speaker, the truth is that we simply don't know whether either the KBA or the Judicial Conduct Commission has received complaints against Judge Goodman or whether they have decided any complaint against her. The impeachment committee directly presented that question to both of those bodies, and neither the Judicial Conduct Commission nor the Kentucky Bar Association would disclose whether any complaints had been filed or any decisions issued regarding Judge Goodman. While they may make their rulings public, they often do not. They may issue private reprimands. In this case, since they refused in writing to disclose whether there have been complaints or decisions, we simply don't know and should not say that there have been no such complaints or decisions against Judge Goodman. Mr. Speaker, at this point, I would urge all of my colleagues to vote yes on House Resolution 124. Without belaboring any point that's been mentioned, I wanted to state that my decision rests on 4 clear pillars. First, the sheer volume of evidence before us, much of it powerfully summarized just moments ago by the gentleman from Jefferson 33. That evidence leaves no doubt that this case meets constitutional standards for finding a misdemeanor in office and grounds for impeachment. Secondly, when the Kentucky Court of Appeals reversed Judge Goodman in the cases discussed by the gentleman from Jefferson 33, it used extraordinarily harsh language that is rare in appellate opinions. That level of criticism is not routine disagreement for which impeachment should never apply. No, that language signals something far more serious. Third, Commonwealth Attorney Kimberly Baird provided credible, straightforward testimony that reinforced the pattern of misconduct and its real-world impact on victims of the justice system. Finally, and most telling, as mentioned by the gentleman from Boone, Judge Goodman herself testified before the House Impeachment Committee that even had she known then what she knows now, she would not change her rulings. That statement amazes me. When the appeals court in our Commonwealth has emphatically declared orders wrong, in error, sometimes in blistering terms, how can a judge say that knowing what the appeals court thinks of her actions and her rulings, she would do it all over again? Mr. Speaker, the evidence is overwhelming. The pattern is unmistakable. Accountability demands that we act. Thank you, Mr. Speaker.
Chair recognizes the gentleman from Carter for discussion of the matter.
Thank you, Mr. Speaker. Permission to speak on the resolution.
Yes, sir.
First, I think it's appropriate to extend our thanks to the members of the committee. Very difficult work. I've reviewed the reports, and I believe all members of the committee conducted themselves very professionally on this matter. Probably more so than any other issue this session, I've wrestled with this one more than any, and that's because what we are doing today is it's extraordinary. It's very serious. We have a resolution before us calling for the impeachment of a sitting circuit judge. Perhaps I take this even more serious as a member of the bar, a practicing attorney. And one thing that I have learned practicing law that although practitioners often become upset and disgruntled with judges, we learn to respect the institution, and we ultimately learn to respect the rule of law. After reviewing the reports, I have decided to vote aye on this measure, and I want to set forth the 2 reasons that I have decided to do that. First, I think it's very important for us to consider our role in this process. I believe sometimes when we hear the word impeachment, it gives people the impression that we are the body, the organization that is removing the person or convicting the person. Really what we are the agency or organization that is charging this person. In this instance, it's the Fayette Circuit Judge set forth in the resolution. And I cannot ignore the testimony and position of the Commonwealth's attorney in Fayette County. That chief prosecutor, who I know of, I do not know personally, I've never had a case against her, nor have I, to my knowledge, ever appeared before this judge. I cannot ignore the fact that this Commonwealth's attorney, the chief prosecutor in Fayette County, feels so strongly about what has happened that she is, in my judgment, arguably put her entire career on the line. That speaks volumes to me. That is something very powerful. And her position as Commonwealth's attorney obviously is to prosecute folks when there's a wrongdoing. And the fact that she came before the impeachment committee and set all the facts out as she sees them, and with her recommendation, leads me to believe that it is appropriate for this body to adopt this resolution and to do our constitutional duty, allow this matter to move forward, and send this matter to the Senate where they can try this matter. I trust that every member of this body will be very conscientious on their votes. I have no ill feelings or about how any of us vote, because this is a very serious matter, but I do think it's very important to amplify what we really are doing as a body here. And I see it as we are acting as the grand juror, and I believe there is enough evidence to allow this matter to move forward, and for those reasons, I will be voting aye. Thank you.
Chair recognizes the lady from Jefferson 35 for discussion of the matter.
Thank you, Mr. Speaker. Will the gentleman yield to a question?
He will yield.
Thank you. Just a couple of, one process question. Gentlemen, were any complaints against Judge Goodman ever brought to the Judicial Conduct Commission that you're aware of?
Gentleman from Jefferson.
I can only say what's of record and not what I personally know. What's of record is that we requested information from the Conduct Commission and they did not respond. And there's a lot of situations where they can't respond, and so I want to respect that.
Lady from Jefferson.
Will the gentleman yield to another question?
He will yield.
So I'm just trying to understand the process here and wondering why we bypassed the Judicial Conduct Commission to bring this case directly to the legislative body.
Gentleman from Jefferson 33.
Thank you, Mr. Speaker. With respect, I don't agree with the way the question was asked. We didn't bypass anything. The Judicial Conduct Commission has independent authority, as does the House of Representatives. We have the constitutional duties, responsibilities to take up a matter that's been presented to us whether it goes to the Judicial Conduct Commission or not. And so I would just respectfully push back a little bit on the language bypass.
Lady from Jefferson 35.
May I speak on the resolution?
Yes, ma'am.
I'll be brief since so many of my concerns have already been addressed by colleagues on both sides of the aisle. I do think that process is incredibly important, and it concerns me, and perhaps bypass wasn't the right word. I'll respect that, but that this came to the legislative body with no action from the Judicial Conduct Commission, with no complaints that we're aware of to that body. And this is such a very, very serious decision we're going to be making today. And I think this will have a chilling effect on people who are currently judges, people who might be considering running for judge, that we seem to be lowering the standard for impeachment here, and that concerns me. I think that's going to have a profound effect, not just on the voters who elected this judge 6 separate times, but I think on our democracy as a whole when we lower those standards for such a serious measure, and I'll be a no today. Thank you, Mr. Speaker.
Chair recognizes the gentleman from Kenton 69 for discussion of the matter.
Permission to speak on the resolution.
Yes, sir.
Mr. Speaker, today I rise in strong support of the resolution adopting articles of impeachment against Circuit Court Judge Julie Goodman. As a member of the House Impeachment Committee, I've read all of the materials over the course of weeks. Petitions to impeach, responses, appellate court reversals, Commonwealth Attorney Kimberly Bard's statement, and every other document that's been submitted to this body. I sat through full open hearings that lasted roughly 4 hours, and I've listened to the judge herself, to the Commonwealth's attorney from Doug Bakken, whose wife, Tammy, was killed in one of the cases, and I've not taken this responsibility lightly. I want to address this argument that there is a procedural flaw, that the petition shouldn't be heard or before this body. When everyone testified before the committee, they did so under oath. And one of the individuals that testified was Judge Goodman's attorney herself. And he admitted that the mere fact that the petition was not verified did not prevent this body from moving forward with impeachment. Judge Goodman's attorney has waived that argument. I want to address this issue of due process. Due process is not ended if we advance this resolution forward. It continues. There will be a trial in the Senate where those witnesses will be subject to cross-examination, the ultimate protection of due process in our system. Let me be crystal clear about what impeachment is and what it is not. It is not about honest disagreements between judges. It's not about appellate court reversals. That's not impeachable. A good faith legal error, even a significant one, does not constitute a misdemeanor in office. The impeachment power must never become a tool to punish judges whose rulings some legislators or litigants simply dislike. There's a bookshelf over there. It contains every single law that's currently on the books. I have sat with so many people in my office who come and say, I'm facing a difficult criminal charge, and I didn't know that what I was doing was a crime. I was ignorant of the law. Every citizen in the Commonwealth is deemed with knowing what is in every one of those books, regardless of whether they know it or not. It's terrifying to me. We've all heard the statistic that you may commit 3 to 5 felonies a day and you don't even know it. It's scary. What's even scarier to me is when someone does know the law and chooses to willfully ignore it. The 2021 Advisory Committee of former Supreme Court justices told us that a misdemeanor in office means willful malfeasance, misfeasance, or non-feasance. That's exactly what we documented in this committee. The gentleman from Jefferson has laid out many of those cases, those 6 cases. And I don't want to waste anybody's time by highlighting them again, but I do want to highlight specifically the Thomas murder case. Cornell Thomas ran a red light at more than 95 miles an hour and killed Tammy Botkin. He severed the vehicle, and he severed her body as well. A Fayette County grand jury indicted him for murder, and Judge Goodman dismissed that murder indictment sua sponte. That means by her own decision. There was no request, no motion. She decided to do it. She alleged, based on her own extrajudicial research into the defendant's sanity, she alleged prosecutorial misconduct and selective prosecution. The Court of Appeals reversed her in a blistering opinion, well over 100 pages. They called it judicial ambush. They said her reasoning was woefully incorrect and that her pursuit of a selective prosecution claim was unique among all American jurisprudence. They surveyed and that she violated the separation of powers by usurping the jury's role. They even suggested sua sponte recusal was the only appropriate solution. Doug Botkin sat in our hearing and described the 2-year nightmare that his family endured after charges were wrongfully dismissed at what they thought was a plea hearing. This was not an error. This was a judge substituting her own will for the law and for a grieving family. Mr. Speaker, these were not isolated mistakes. The Court of Appeals reversed Judge Goodman in every single case we reviewed, often using unusually direct and critical language. Commonwealth's attorney testified that the defendants win suppression motions in Judge Goodman's case at about an 80% rate, compared to just 12 or 32% in the other 4 Fayette divisions. Prosecutors and victims are often publicly humiliated in her courtroom. We had testimony on a case where a domestic violence victim was blamed because she stayed in the situation after her son was murdered. The people of the Commonwealth elected us to uphold the Constitution, and I think that we should do that. I urge every member of this House to vote yes on the resolution adopting articles of impeachment and transmit them to the Senate. Thank you, Mr. Speaker.
Gentleman from Jefferson, 33.
Thank you, Mr. Speaker. I'll make just a couple points. One, just by way of clarification, people have talked about 71,000 or 72,000 cases. Most of those are traffic ticket cases. When she was a district judge, I just want to note that those are important, but that's the kind of case that majority of those have been. Also want to note the due process thing. I thank the gentleman from Kenton 69. I want to note that we could have brought this motion without hearing from Judge Goodman. We decided that wasn't right. We wanted to hear. We wanted from her. We wanted her to have an opportunity to defend herself. We let her lawyers have all the time they wanted. We let her have all the time she wanted. She spoke before and first and last. We didn't have to give her any of those things. The due process argument is a red herring. The due process will come, as the gentleman from Kenton 69 said, in the Senate, when there will be time for her to make her case, confront witnesses. And I did offer them the opportunity to submit questions to the committee, and we would ask them. They deliberately decided not to ask any. So the due process argument I wanted to note. The final thing, Mr. Speaker, misdemeanor in office, and everybody on the floor knows it. I understand you have to present your case, but the misdemeanor in office is not a crime, doesn't require a crime. It's defiance of the rule of law, neglect of duty, misconduct in office. It is broad enough to embrace any willful malfeasance, misfeasance, or nonfeasance in office. This is not failure to follow binding precedent. There were cases today, just an hour ago, that the Court of Appeals has reversed on other judges. We're not talking about any of that. It happens every Friday. We're talking about this judge because She is a law unto herself. On page 400 of the documents that Kimberly Baird has submitted, the judge says this on the record in court. She's having a colloquy with the attorney for a defendant. And this is on April 27, 2023. Well, I think if people who really know me know I've always been an advocate. This is a judge in a black robe on the bench. Mr. Speaker, this is not a reversal. This is not getting it wrong on the law. This is intentionally ruling in a way that she knows is against the law. Imagine, Mr. Speaker, if that was your son who had been murdered. Imagine if it were your wife who had been severed and hit and the grand jury had indicted. Imagine if it were you in one of the worst days of your life in court and the judge says you're right on the law. But I'm not going to enter that order because I don't want to. Imagine if it were you. That is not a judge, Mr. Speaker. That is an advocate. You want to set a precedent? We need to set it clearly here today. If you're a judge and you do your job honorably and you get it wrong, we will fight for you. We will never have these proceedings. But if you will say, I know the law says this, but I'm going to do that instead, then you do not deserve the black robe that you have been entrusted with. Mr. Speaker, I know I'm getting worked up, but I'm going to say this. I did not want to be here. I haven't slept in a month. I have a heavy, heavy heart. Judge Goodman ought not be a judge in the Commonwealth of Kentucky. And that's why I ask, with everything I have, passage, I move for adoption of H.R. 124.
Motion is for the adoption of House Resolution 124. Clerk will sound the chimes. Those in favor vote aye. Those opposed, nay. Roll call is open for your vote. Have all members voted? Does any member wish to change or explain their vote? Clerk will take the roll. Means 73 members voting aye, 14 members voting nay. House Resolution 124 is passed. Gentleman from Jefferson, 33.
Move the clincher.
Without objection, clincher is applied.
Chair recognizes the gentleman from Bullitt.
Thank you, Mr. Speaker. The Enrollment Committee has met and found the following bill to be in order and ready for your signature. Senate Bill 2.
Chair is about to sign Senate Bill 2. Lady from Davis.
Thank you, Mr. Speaker. The Clerk of the Senate.
Chair recognizes the Clerk of the Senate.
Thank you, Mr. Speaker. The Senate has passed Senate Bill 223 and respectfully request concurrence of this honorable body. Mr. Speaker, the Senate has passed House Bill 312 and is returning same to this honorable body. And Mr. Speaker, the Senate has passed House Bills 134, 185, 213, 220, 265, 355, 424, 456, and 622, all with letter, and respectfully request concurrence of this honorable body.
Thank you, Madam Clerk.
Thank you, sir.
Lady from Davis.
The Senate has been busy. Thank you. Mr. Speaker, I move that House Bill 900 with Senate amendment be taken from the orders of the day for concurrence or non-concurrence.
Motion made that House Bill 900 with Senate amendments attached thereto be taken from the orders of the day for concurrence or non-concurrence. Mr. Clerk, please report.
House Bill 900, an act relating to government agencies, making an appropriation therefore and declaring an emergency. Representative Petrie.
Lady from Davis.
Mr. Speaker, I move that the House not concur in the Senate committee substitute to House Bill 900.
Mr. Clerk, please report City Committee Substitute 1.
Senate Committee Substitute 1 to House Bill 900.
Now, Lady from Davis, make that motion, please.
I will try again. Mr. Speaker, I move that the House not concur in the Senate committee substitute to House Bill 900.
Motion made that the House does not concur to Senate Committee Substitute 1 in House Bill 900. Is there any discussion? All those in favor, please signify by saying aye. Aye. All opposed, nay. Motion carries. The House does not concur with Senate amendments on House Bill 900. Madam Clerk, please communicate with the Clerk of the Senate requesting that the Senate recede from its amendments on House Bill 900. Lady from Davis.
Mr. Speaker, I move that Senate Bill 245 be taken from its place in the orders of the day, read for the third time by title and sponsor only, and placed upon its passage.
Motion made that Senate Bill 245 be taken from its place in the orders of the day, read for third time by title and sponsor only, and placed upon the floor for its passage. Mr. Clerk, please report.
Senate Bill 245, an act relating to tobacco, nicotine, or vapor product licensure and declaring an emergency. Senator Webb.
Lady from Davis.
Speaker, I yield to the gentleman from Bourbon 72 for explanation of the bill and motion thereon.
Chair recognizes the gentleman from Bourbon for an explanation of the bill and a motion thereon.
Thank you, Mr. Speaker. Senate Bill 245 is a cleanup from Senate Bill 100 as we enacted last session. Straightforward bill to provide ABC with clear guidelines regarding tobacco licensing. Senate Bill 245 does not diminish or eliminate any provision set forth by the General Assembly enacted previously, but rather it clarifies and prescribes the intent and implementation of the tobacco licensure provisions. So specifically, it clarifies what information is required for licensure. It puts in the deadlines for obtaining the license, the timeline for issuing to the license, and the entire licensing process. It aligns with the delayed implementation dates to ensure that all retailers are legally licensed this year as intended. It does, Mr. Speaker, it does come with a committee sub from the gentleman from Christian 8. Simply, this is about shipment, making sure that shipment for any of these products is being received by a person of 21 years of age or older, and sets forth, much like we do with alcohol, it just sets forth the verification process to make that happen. It also has punishments in there. That being said, if there are no questions, I'd ask the clerk to please report House Committee Sub 1.
Mr. Clerk, please report.
House Committee Substitute 1 to Senate Bill 245.
Gentleman from Bourbon.
Move passage.
Motion made for the adoption of House Committee Substitute 1. Is there any discussion? Seeing none, all those in favor, please signify by saying aye. Aye. All opposed, nay. Motion carries. House Committee Substitute 1 is adopted. Gentleman from Bourbon.
Mr. Speaker, we also have House Floor Amendment 1, I believe. Yes, House Floor Amendment 1. House Floor Amendment 1, there was a letter that came over from the cabinet, did not get to the bill sponsor until the day before the committee. So she has taken into account what provisions could be agreed upon there and fixed that in Floor Amendment 1. There's also provision on there allowing for some sponsorship, fairs and festivals, and obtaining a temporary license to do that. So that is simply an agreement between the cabinet and the bill sponsor in House Floor Amendment 1, and I'd ask the clerk to please report.
Mr. Clerk, please report.
House Floor Amendment 1 to Senate Bill 245.
Gentleman from Bourbon.
Move passage.
Motion made for the adoption of House Floor Amendment 1. Is there any discussion? Seeing none, all those in favor, please signify by saying aye.
Aye.
All opposed, nay. Motion carries. House Floor Amendment 1 is adopted. Gentleman from Bourbon.
Mr. Speaker, I move passage of Senate Bill 245 as amended by House Committee Sub 1 and House Floor Amendment 1.
Motion made for the passage of Senate Bill 245 as amended by House Committee Substitute 1 and House Floor Amendment 1. Is there any further discussion? Seeing none, Mr. Clerk, sound of chimes. We'll now proceed to vote. All those in favor, please signify by voting yea on the roll call machine. Those opposed, nay. And the roll call machine is open for your voting. Have all members voted? Would any member like to change or explain their vote? Clerk will take the roll. There being 85 members voting yea, no members voting nay, Senate Bill 245 as amended by House Committee Substitute 1 and House Floor Amendment 1 is passed. Gentleman from Bourbon.
Move clincher.
Without objection, the clincher is applied. Lady from Davis.
Thank you, Mr. Speaker. I move that Senate Bill 46 be taken from its place in the orders of the day, read for the third time by title and sponsor only, and placed upon its passage.
Motion made that Senate Bill 46 be taken from its place in the orders today, read for the third time by title and sponsor only, and placed upon the floor for its passage. Mr. Clerk, please report.
Senate Bill 46, an act relating to school transportation and declaring an emergency. Senator Deneen.
Lady from Davis.
Mr. Speaker, I yield to the lady from Jefferson 37 for explanation of the bill and motion thereon.
Chair recognizes the lady from Jefferson 37 for an explanation of the bill and a motion thereon.
Thank you, Mr. Speaker. In session 2024, we allowed public school transportation to include 9-passenger vans as part of regular routes. It was a great bill, great sponsors, but the promulgating of the regulations, not so much. So we addressed those concerns and challenges with this bill, sub, and amendment. As I'm sure no one here really cares to hear about the tedious process it took to get us to where we landed after countless discussions with the cabinet and stakeholders, I'd like to present the bill as it will finally be passed and handle the clerical activity at the end, if you'll bear with me. So as mentioned, we were specific about the vans being 9-passenger, and that was due to the market and safety requirements. However, 10-passenger vans are now being manufactured, so we allow for those as they still do not require a CDL to drive, and they are still considerably safer than the 12 to 15-passenger vans. So when the cabinet promulgated the regulations, there was no distinction made between the routine drivers and the extracurricular drivers. And while we recognize there is a clear distinction between a regular route and extracurricular activities, thinking of volunteers, coaches, etc., we wanted to codify the distinction. We want to provide clear intentions for the cabinet to promulgate the regulations as such. Our number one concern is safety for our students. So with our distinction outlined, for both the cabinet and superintendents, we will require an initial and, as practicable or feasible, valid driver's license, state criminal background check, driving record, drug test, and a 3-hour training on the van, student safety, and a basic first aid and CPR instruction. These we consider the bare minimum for all adults transporting our precious cargo. The CDL and additional training will still be required for bus drivers. Additional training will still be required for those driving vans as part of the routine routes. Superintendents will, with this bill as amended by the sub and floor amendment, be allowed to add additional training and qualifications as they deem necessary. This bill will set regulation standards mandatory for our student safety as well as allow for flexibility within our districts to account for our various landscapes throughout the Commonwealth. So, Mr. Speaker, I ask that the clerk to report the House Committee substitute to Senate Bill 46.
Mr. Clerk, please report.
House Committee Substitute 1 to Senate Bill 46.
Lady from Jefferson.
Mr. Speaker, I move adoption of the House Committee substitute.
Motion made for the adoption of House Committee Substitute 1. Is there any discussion? Seeing none, all those in favor, please signify by saying aye. Aye. All opposed, nay. Motion carries. House Committee Substitute 1 is adopted. Lady from Jefferson.
Mr. Speaker, I ask the clerk to report House Floor Amendment 2.
Mr. Clerk, please report.
House Floor Amendment 2 to Senate Bill 46.
Lady from Jefferson.
I move adoption of the House Floor Amendment 2.
Motion made for the adoption of House Floor Amendment 2. Is there any discussion? Seeing none, all those in favor, please signify by saying aye. Aye. All opposed, nay. Motion carries. House Floor Amendment 2 is adopted. Lady from Jefferson.
Mr. Speaker, I move passage of Senate Bill 46 as amended by the House Committee Substitute 1 and House Floor Amendment 2.
Motion made for the passage of Senate Bill 46 as amended by House Committee Substitute 1 and House Floor Amendment 2. Is there any further discussion? Seeing none, Mr. Clerk, sound the chimes and now proceed to vote. All those in favor, please signify by voting yea on the roll call machine. Those opposed, nay. And the roll call machine is open for your voting. Have all members voted? Would any member like to change or explain their vote? Clerk will take the roll. There being 87 members voting yea, 2 members voting nay, Senate Bill 46 is amended by House Committee Substitute 1 and House Floor Amendment 2 is passed. Lady from Jefferson.
I move the clincher.
Without objection, the clincher is applied. Chair recognizes the gentleman from Bullitt, Chair of the Enrollment Committee.
Mr. Speaker, the Enrollment Committee has met and found the following bill to be in order and ready for your signature. House Bill 312.
Chair is about to sign House Bill 312. Thank you. Lady from Davis.
Thank you, Mr. Speaker. Mr. Speaker, I move that House Bill 889 be taken from its place in the orders of the day, read for the third time by title and sponsor only, and placed upon its passage.
Motion made that House Bill 889 be taken from its place in the orders today, read for the third time by title and sponsor only, and placed upon the floor for its passage. Mr. Clerk, please report.
House Bill 889, an act relating to operations within the Department of Corrections and declaring an emergency. Representative Decker.
Lady from Davis.
Mr. Speaker, I yield to the lady from Shelby 58 for explanation of the bill and motion thereon.
Chair recognizes the lady from Shelby.
Mr. Speaker, House Bill 889 is an act relating to the operation within the Department of Corrections and declaring an emergency, as you just heard. It is, thankfully, a very simple bill for today. All it does is include the medical corrections complex that is nearing completion as part of the Department of Corrections organization. This complex was authorized and appropriations were made for it in prior years. It just now needs to be added to the statute as part of the organization. If there are no questions, Mr. Speaker, I ask for adoption of House Bill 889.
Motion made for the passage of House Bill 889. Is there any discussion? Seeing none, Mr. Clerk, sound the chimes. Now proceed to vote. All those in favor, please signify by voting yea on the roll call machine. Those opposed, nay. And the roll call machine is open for your voting. Have all members voted? Would any member like to change or explain their vote? Clerk will take the roll. There being 91 members voting yea, no members voting nay, House Bill 889 is passed. Lady from Shelby.
Mr. Speaker, I move the clincher.
Without objection, the clincher is applied. Lady from Davis.
Mr. Speaker, I move that Senate Bill 5 be taken from its place in the orders of the day, read for the third time by title and sponsor only, and placed upon its passage.
Motion made that Senate Bill 5 be taken from its place in the orders of the day, read for the third time by title and sponsor only, and placed upon the floor for its passage. Mr. Clerk, please report.
Senate Bill 5, an act relating to Kentucky-grown agricultural product procurement. Senator Howell.
Lady from Davis.
Mr. Speaker, I yield to the gentleman from Christian 9 for explanation of the bill and motion thereon.
Chair recognizes the gentleman from Christian 9 for a brief explanation of the bill and motion thereon.
Thank you, Mr. Speaker. Ask the clerk to report House Committee Sub 1, please.
Mr. Clerk, please report.
House Committee Substitute 1 to Senate Bill 5.
Gentleman from Christian.
Move adoption.
Motion made for the adoption of House Committee Substitute 1. Is there any discussion? Seeing none, all those in favor, please signify by saying aye. All opposed, nay. Motion carries. House Committee Substitute 1 is adopted. Gentleman from Christian.
Mr. Speaker, one moment. Excuse me, Mr. Speaker. Ask the clerk to call the House Committee Amendment 1, the title amendment. Oh, excuse me. I'm sorry. This one kind of threw me. I apologize right there. Excuse me right there. Senate Bill 5 will allow our school districts to actually be able to contract with local growers and purchase produce. And the go with this will allow for us to create the possibility of distributions there within our local areas and actually help our producers as well and make sure our young people get good, healthy, homegrown food. With that, if there are no questions, I'd move passage of Senate Bill 5 as amended by House Committee Sub 1.
Motion made for the passage of Senate Bill 5 as amended by House Committee Substitute 1. Is there any discussion? Seeing none, Mr. Clerk, sound the chimes. Now proceed to vote. All those in favor, please signify by voting yea on the roll call machine. Those opposed, nay. And the roll call machine is open for your voting. Would any member like to change or explain their vote? Clerk will take the roll. There being 92 members voting yea, no members voting nay. Senate Bill 5 as an amendment of the House Committee Substitute 1 is passed. Gentleman from Christian.
Ask the clerk to report House Committee Amendment 1, the title amendment, please.
Clerk, please report.
House Committee Amendment 1, the title amendment to Senate Bill 5.
Gentleman from Christian.
Move adoption.
Without objection, so ordered. Gentleman from Christian.
Move the clincher.
Without objection, the clincher is applied. Lady from Davis.
Good. It's a team effort, gentlemen from Christian. Thank you. Mr. Speaker, I move that Senate Bill 4 be taken from its place in the orders of the day, read for the third time by title and sponsor only, and placed upon its passage.
Motion made that Senate Bill 4 be taken from its place in the orders of the day, read for the third time by title and sponsor only, and placed upon the floor for its passage. Mr. Clerk, please report.
Senate Bill 4, an act relating to school leadership. Senator West.
Lady from Davis.
Mr. Speaker, I yield to the gentleman from Spencer 53 for explanation of the bill and motion thereon.
Chair recognizes the gentleman from Spencer for an explanation of the bill and motion thereon.
Thank you, Mr. Speaker. Senate Bill 4, as drafted by the senator from Bourbon, is an effort that we've talked about for the last couple of years. One thing that has become apparent that one of the reasons that teachers do not stay in schools, they do not stay in the profession, is the lack of leadership in the building. So that's what the emphasis of Senate Bill 4 is about. It sets up it's going to be amended by the committee sub, but it sets up a 3-year program for principals to receive mentorship, to receive training, and help them to improve their position in the schools. Now, I'll be happy to entertain any questions on that, but I know we've got a lot more to discuss about this issue. So at this time, Mr. Speaker, would you ask the clerk to report House Committee Sub 1?
Mr. Clerk, please report.
House Committee Substitute 1 to Senate Bill 4.
Gentleman from Spencer.
Mr. Speaker, I yield to the gentleman from Jefferson 48 for explanation of the committee sub.
Chair recognizes the gentleman from Jefferson 48.
Thank you, Mr. Speaker. Would you have the clerk report House Floor Amendment 1, and then I will talk about things in entirety.
Gentlemen, one of you two needs to adopt the committee sub. Whoever wants to make the motion.
Mr. Speaker, I move for adoption, House Committee Sub 1.
Motion made that we adopt House Committee Substitute 1. Is there any discussion? Seeing none, all those in favor, please signify by saying aye. Aye. All opposed, nay. Motion carries. House Committee Substitute 1 is adopted. Now, gentleman from Jefferson.
Thank you, Mr. Speaker. Would you have the clerk call House Floor Amendment number 1?
Mr. Clerk, please report.
House Floor Amendment 1 to Senate Bill 4.
Gentleman from Jefferson.
Move for adoption.
Motion made for the adoption of House Floor Amendment 1. Is there any discussion? Chair recognizes the lady from Jefferson 35.
Thank you, Mr. Speaker. Will the gentleman yield to a question?
He will yield.
Thank you. So, gentlemen, I've had some questions from school board members about this. So one of them reached out to me last night saying they'd heard that this amendment stipulates that all board members in Jefferson County would be appointed rather than elected. That's not my understanding of what this amendment does, but can you clarify that?
Gentleman from Jefferson.
Thank you, Mr. Speaker, and thank you, lady from Jefferson 35. And first of all, I want to insert. I do appreciate our communications in terms of going through and working this whole project. No, the school boards are not. All of them are not appointed. There's going to be a combination of 5 elected and 2 appointed. The 2 appointed will be coming from the state treasurer. That those individuals have to have at least 10 years of financial background experience and understanding for them to be appointed to the boards.
Lady from Jefferson.
Thank you. Will the gentleman yield to another question?
He will yield.
Thank you. The committee sub includes language to prohibit a full-time school employee in a different district from running for school board, and there had been some questions and concerns about that. Is that provision removed in the amendment, or is that still in the committee sub?
Gentleman from Jefferson.
Thank you, Mr. Speaker, and thank you, lady. I want to yield to the gentleman for Ohio to cover that briefly. He has more of a background experience in terms of how it affects the whole state.
Gentleman from Ohio.
Thank you, Mr. Speaker. What's currently in there, lady from Jefferson, is in the 2 largest school districts, a full-time teacher in another district may not be eligible to be a school board member. The law currently in Kentucky, a school board member cannot be a teacher that is in the home district. And right now it's allowed that if they live outside a district, they could be a school board member. So it was also put in the amendment, I do believe, that it does allow for part-time teachers or employees that work no more than 100 days per year could still be a school board member.
Lady from Jefferson.
Thank you. Will the gentleman yield to another question?
No.
How about the other gentleman?
Now go ahead.
He will yield.
I think this is for the gentleman from 48, but thank you to the gentleman from Ohio. This was obviously a group project, which I appreciate. I've expressed some discomfort about having the appointed members on the board, and I believe that the amendment helps with my concerns. Does the amendment stipulate that only publicly elected members can be elected chair or vice chair of the school board?
Gentleman from Ohio.
Yes, that's correct. The elected members would serve as chair or vice chair. The two appointed members could not be chair or vice chair during their terms.
Lady from Jefferson.
Thank you. I directed it the wrong direction. So this next one also goes to the gentleman from Ohio, if he will yield.
He will yield.
Thank you. Gentlemen, does the amendment include term limits for the appointed members?
I believe it's excuse me, Mr. Speaker.
May proceed.
I believe it's 2 consecutive 4-year terms.
Very
Lady from
much.
Jefferson.
Thank you. That's all I've got for the amendment. Thank you.
Chair recognizes the lady from Fayette 93 to speak on the amendment.
Yes, please.
May proceed.
Actually, may I ask one of the gentlemen a question?
He will yield.
Thank you. And I'm not sure which one this one will go to. I'm trying to clarify what the amendment does as far as people who live in one county but work full-time in a different public school. So in the 2 largest counties, if I'm understanding correctly, and I'll just use Fayette as an example, I reside in Fayette County, but say I taught in Fleming County. Does this amendment then prohibit me from being able to serve and run for office and serve on the Board of Education in Fayette County, the county in which I live?
Gentleman from Jefferson. Gentleman from Ohio, you're at bat.
If you work more than 100 days a year, it would preclude you from being on that board.
Lady from Fayette.
May I ask another question?
Here with you.
Oh, thank you. And does this go for any employee, whether it's a classified hourly employee, certified salary, a teacher, principal, administrator?
Gentleman from Ohio.
I believe in the bill it says 100-day employee. It doesn't specify. So if you had a classified employee that worked less than 100 days, they could serve on the board.
Lady from Fayette.
Thank you. May I ask one more question?
Here with you.
Okay, and actually this will go to the gentleman from Jefferson.
So you will also yield.
Thank you. One of the areas of concern that I had brought up in the amendment, actually I take this back. This is not in the amendment. This is in the original bill. So wait, I think that's all for right now.
Gentleman from Carter, would you like to speak on the amendment?
Question on the amendment.
May proceed.
The gentleman from Jefferson 48 yield for a question.
Here with you.
In this floor amendment, are there any distinctions between the elected and non-elected board members on their rights, powers, and responsibilities?
Gentleman from Jefferson.
No, sir, not aware of.
Gentleman from Carter.
That's all I have, Mr. Speaker.
Question for the body is on adoption of House Floor Amendment 1. All those in favor, please signify by saying aye. Aye. All opposed, nay. Motion carries. House Floor Amendment 1 is adopted. Gentleman from Jefferson.
Hold on a second. Thank you, Mr. Speaker. I'd like to go ahead and move that the Senate Bill number 4 move for passage with amended by House Committee Substitute 1 and Floor Amendment 1. And I'm not too sure if I should do that or the gentleman from Spencer should do that.
Well, since you made the motion, we're going to go ahead and accept it.
Well, thank you very much, sir. And thank you for your indulgence, the gentleman from Spencer.
Motion made that Senate Bill 4, motion made for passage of Senate Bill 4 as amended by House Committee Substitute 1 and House Floor Amendment 1. Is there any discussion? The chair recognizes the lady from Fayette 93.
Thank you. Sorry, I just hadn't turned off my request to speak button, but since I'm up, may I ask the gentleman from Jefferson a question, please?
He will yield, but just remember those buttons will turn back off, too.
Gentlemen, I had communicated with you one of my concerns in the first part of that bill. that deals with changing language from the current internship program for principals. There are 39 other states in the United States that require principals to have an internship as part of their certification process. And my hope was that we could fix this bill so that in the event one of our superintendents, I'm sorry, not superintendents, principals who left the state for whatever reason and wanted to serve in another state would not be precluded from doing so without getting additional education or requiring an internship year. Is that something that can be addressed? And I think the gentleman from Ohio.
Gentleman from Ohio.
Thank you, Mr. Speaker. I think what you're referring to, that would be up to that particular state that was receiving the principal, if they if they would accept our certifications or not.
Lady from Fayette.
That is, sorry, may I continue? Thanks.
May proceed.
Thank you. Yes, that is up to the state, that is up to the state receiving, but my hope is that we could do just a very simple tweak in that bill so that we can call the first year of the new leadership program an internship, so that there wouldn't be any questions or any issues with the principal moving to another state.
Gentleman from Ohio.
Duly noted.
Lady from Fayette.
Thank you. May I speak on the bill?
May proceed.
I really appreciate all of the work that has gone into this bill. And originally, when SB 4 came out of the Senate, it was an exceptional bill, and it was one that I would have been easily able to support. But given that with the changes that have taken place with the adoption of amendments and committee subs, it's denying people who live in the two largest counties and who may work in other school districts, it's preventing them from being able to serve their communities in which they live and to bring their knowledge and their experience in working in a school to their school board. So I encourage everyone to take a moment and think about what that would mean in your district. If you're trying to encourage people to run for school boards, because there are districts where it is hard to find individuals to run. But it is doing harm to Jefferson County and Fayette County specifically when we deny citizens the right to run for office. So I will be a no. Thank you.
Chair recognizes the lady from Jefferson 35.
Thank you, Mr. Speaker. Will some gentleman or another yield to a question?
One of them will yield.
Excellent. So this is another question that came to me from a Jefferson County School Board member, and I promised that I would ask it on the floor. With this bill, each elected member will represent 32 schools and 160,000 constituents. Can you explain how that structure is expected to improve academic outcomes?
Gentleman from Jefferson.
Thank you, Mr. Speaker. I appreciate that. That's a good question. Basically, where we're coming from is that we're just going to be 7 individuals on this board, and we need to have a high level of confidence in making sure that the board has the resources and the understanding from a financial point of view. There will be, as you know, and you being on the school board itself some years ago, there's a lot of support system in order to help maintain and provide services to their constituents within the district. Part of the process that I feel that's good to have some financial expertise that will change a little bit of the structure is because these individuals can go through and analyze, scrub, review, scrutinize a lot of these financial budgets, and then when you look at that process, that provides a higher accountability for all the board members in order to make sure those tax dollars are put back into the classroom to help out with teachers' pay, to help out with our children, and making sure that they are in a better position in order to contribute to society and provide for the families. So when you look at the 5 elected, I'm already looking at the 7 because I think look at them totally in its totality. They all are serving everybody, even though they have certain districts of, you said, the 36,000. I think you're looking at the whole thing because there is a support structure in order to help provide those services.
Lady from Jefferson.
Thank you. Will the gentleman yield to another question?
He will yield.
Thank you. So, gentlemen, as you know, I voted yes on this in committee, pending some changes, and you've made some of those changes, and I really appreciate that. And I anticipate that I'll be a yes again today on the floor. But one of the questions that has been posed to me, and I'll ask you, and I know we can't predict the future of what some future legislative body might do, but do you anticipate that if we pass this bill, it'll be a slippery slope where we continue to take away more and more elected positions, add more appointed, continue to tinker with Jefferson County Public Schools, or do you anticipate we might see how this works and give it some time?
Gentleman from Jefferson.
That's a very good question. I do really appreciate that. When it comes to elected positions, I can tell you flat out, I'm not going down the appointment process for the whole board. I just think that's taken away the election process and having people have a buy-in to the process to select who they want to go on the board. So I'm not in favor of a total appointment process. I think when we look at down the road, I can't promise anything. I'm not going to really sit there and continue to tinker and play with it because I don't know. I would like to see how this unravels and see how it goes, And if we can come back a year or 2 years and see how it's progressing, then we can address it. And there might be some issues, and I think we all recognize that. But I'm not really want to go through and continue to tinker with the board and so forth. But I am overly concerned of the governance of the board and the structure of the board and how it's functioning and how it's accountable to the districts to make sure our kids are in the best position possible. So when it comes to governance, I've always been a very strong person when it comes to making sure we have an infrastructure to set up from a governance standpoint, have the committees in order to provide not only human resources but also facility management, the financial point of view, as well as teachers and how we help them out and provide that. So that's I really don't want to keep tweaking this, but let's see how it goes and let's hope it works out the way we anticipate it's going to.
Lady from Jefferson.
Thank you, gentlemen. Thank you, Mr. Speaker. May I speak on the bill?
May proceed.
Thank you. I want to say that I'm a strong champion and supporter of our public schools. I'm a product of public schools myself. Both of my children went to JCPS K through 12. And anyone who knows my work on the Jefferson County Board of Education and anyone who knows my voting record in this legislature will be very clear about my consistent and dedicated support of public education, the success of our students, and support for our teachers, school leaders, and classified staff. I've long made the case that school funding has not been adequate for our schools to be successful, and I've made the case session after session that legislative interference often makes things harder for our public schools rather than better. And I still believe that we need to live up to our constitutional requirement to adequately and equitably fund our public schools. My commitment to our public schools has not changed and won't ever change. But what has changed is that our two largest school districts have made some financial missteps. In JCPS, the independent auditor can't even tell exactly where the money went or how big the budget shortfall is. That has left the board and our brand new superintendent in an untenable position. This has shaken the confidence of students, parents, teachers, and taxpayers. It has shaken my trust. We need a path, a democratic path, small d democratic path to restore trust. And I'll be frank, this body is not going to allocate more resources to our public schools until fiscal responsibility is clear. I don't think this bill is perfect. I have serious reservations about the appointed board members, But I know that many states and municipalities have appointed board members, have some hybrid like this is proposed, and overall it has not been harmful to student achievement. So I'm willing to try something new. In fact, I think we have to try something new. I voted yes in committee with assurances that the floor amendment would make the bill better, and in fact it has, and I want to thank a number of people on this floor for their work on that. I thank you for your willingness to work with me, and I'm hopeful that this is going to be a positive step for our schools, and that we will get our schools the support that they need to be successful for every student in this Commonwealth. Thank you.
Chair recognizes the gentleman from Rockcastle.
Thank you, Mr. Speaker. Will the gentleman from Spencer yield to a question?
He will yield.
I've gone through the original provisions of Senate Bill 4, and I don't see an appropriation or a fiscal impact. I just want to clarify and make sure that's the case, provided we pass this, that there is no fiscal impact.
Gentleman from Spencer.
Thank you. Thank you, gentlemen from Rockcastle. I thought nobody would ask me a question. But I do know the answer to that question. The legislation says it's the intent of the General Assembly that neither the school district or the principal would endure any financial cost to this. And in the third year of the principal program, that principal will receive a stipend. In testimony in the committee, Senator West shared that is something he wants to work through the budget process if those funds are available.
Gentleman from Rockcastle.
Thank you, Mr. Speaker.
Chair recognizes the lady from Jefferson 32.
Yes, sir. May I speak on the bill?
May proceed.
Following my colleague from Jefferson, I am JCPS. I graduated from Central High School. All three of my children graduated from JCPS, and I'm currently an employee of the district. From my perspective, we need to do something to increase the confidence in our school district. There are so many amazing things happening in Jefferson County Public Schools. There's a disconnect between what individuals find based on their experience often and public perception about the district, which has been enhanced or complicated by the budget shortfall. We need to do something to increase the confidence in Jefferson County Public Schools, both in this body and in the community. I support this bill, despite the angst that it may cause me for taking this vote, but we have to do something. And we need to move forward and not just be having a war on JCPS, but doing something constructive. And I think that in this bill, we are making constructive, well thought out steps to move the district forward. Thank you.
Chair recognizes the gentleman from Jefferson 48.
Thank you, Mr. Speaker. I just want to take no more 1 minute to express my deep appreciation and the collaboration and cooperation from the lady from District 32, the lady from 35, the gentleman from District 79, the lady from 93, the gentleman from Jessamine 39, and the gentleman from 14, and our good friend, gentleman from 33rd, in making this come together. So thank you very much.
Mr. Clerk, sound the chimes. Now proceed to vote. All those in favor, please signify by voting yea on the roll call machine. Those opposed, nay. And the roll call machine is open for your voting. Have all members voted? Would any member like to change or explain their vote? Chair recognizes the gentleman from Jefferson 30 for explanation of vote not to exceed 2 minutes.
Thank you, Mr. Speaker. JCPS is in my district. My wife is a 20th year teacher at JCPS. I myself am a former employee of JCPS. I hear about JCPS from voters on a regular basis, nearly every person I speak to, and the words that I hear are so unkind, and the language is the type that I could not repeat on this floor without censure. I hear much more extreme words regarding reckless spending, complete dysfunction and even accusations of outright criminal conduct involving theft and fraud. It's not easy for me to vote in favor of a bill that's going to overhaul the system, but it's absolutely necessary and mandatory. That said, I personally have full faith and confidence in the new superintendent, Dr. Yearwood, and I hope that everyone in this body gives him sufficient opportunity to conduct himself before any further action is taken that may result in yet another leadership change. Thank you, Mr. Speaker.
Chair recognizes the lady from Fayette 93 for explanation of vote not to exceed 1 minute.
Thank you, Mr. Speaker. I had high hopes for this bill when it came from the Senate. I had high hopes when we discussed it and voted on it in committee. I was hoping that there would be positive changes. And there were some changes. But I caution everyone in this chamber, when you vote to take away somebody's right to run for office, we are not doing good things for the Commonwealth. We are causing harm. You have to ask yourself, what is the reason? Why would we want to deny individuals who live in a community the opportunity to run for their local school board? I'm proudly voted no. I'm sad to see this bill pass, and I am sorry to everyone who wants to run for office and serve their community, but now find that one in which they may have a passion for education. I'm sorry for those who will no longer be able to run for office based on this bill. Thank you.
Chair recognizes the gentleman from Jefferson 39. Jessamine 39.
Thank you, Mr. Speaker. I'm not sorry for my yes vote because as someone that represents part of Fayette County, I believe it is incumbent on all of us to make sure that we do the right thing for students, to make sure that we do the right thing for parents, for teachers, and I believe that this bill is a good step towards that first thing. Over the last probably year to year and a half, I have heard from countless teachers and parents and students out of Fayette County begging, asking for our help, asking for us to step in and do something. And I believe that Senate Bill 4 is a great first step because we have to step in. We have to make sure that our students and our parents are getting that education that they deserve, and it's incumbent on us to provide that. So I proudly and gladly vote yes on Senate Bill 4. Thank you, Mr. Speaker.
Clerk will take the roll. There being 74 members voting yea, 15 members voting nay. Senate Bill 4 is amended by House Committee Substitute 1 and House Floor Amendment 1 is passed. Gentleman for Spencer.
Mr. Speaker, would you ask the clerk to report House Committee Amendment 1, the title amendment?
Mr. Clerk, please report.
House Committee Amendment 1, the title amendment to Senate Bill 4.
Gentleman for Spencer.
Move for passage.
Without objection, so ordered. Gentleman from Spencer.
Move the clincher.
Without objection, clincher is applied. Lady from Davis.
That concludes the orders of the day.
Next order of business, motions, petitions, communications, and announcements. Lady from Davis.
Mr. Speaker, to the lady from Jefferson 41, I did the best I could to get us to tip off. Okay, so that one's for you. Mr. Speaker, I move that House Resolution 120 be taken from the Committee on Committees and brought to the House floor.
Without objection, so ordered. Lady from Davis.
Mr. Speaker, I move that Senate Bill 1 be taken from the Committee on Committees, given to a second reading, and returned to the Committee on Committees.
Without objection, so ordered. Mr. Clerk,
Mr. Speaker,
report.
I move that House
Hold on,
Bill...
Lady, hold on, lady.
I'm
just
sorry.
a second. Mr. Clerk, please report.
Senate Bill 1, Senator Givens, an act relating to education.
Now, Lady from Davis.
Mr. Speaker, I move that House Bill 515, House Bill 546, House Bill 547, House Bill 614, House Bill 640, House Bill 674, and House Bill 675 be taken from the Committee on Appropriations, given a second reading and returned to the Committee on Appropriations and Revenue.
Without objection, so ordered. Mr. Clerk, please report.
House Bill 515, Representative Petrie, an act relating to revenue. House Bill 546, Representative Petrie, an act relating to taxation. House Bill 547, Representative Petrie, an act relating to fiscal matters. House Bill 614, Representative Petrie, an act relating to revenue. House Bill 640, Representative Petrie, an act relating to taxation. House Bill 674, Representative Petrie, an act relating to branch budget recommendations. And House Bill 675, Representative Petrie, an act relating to fiscal matters.
Lady from Davis.
Mr. Speaker, before people start to scatter, which they already have, just a reminder, you should have already received correspondence that we will not be meeting on Monday. We will not be meeting on Monday, so just kind of a heads up on that item, and keep several of our members and their families in your prayers. Another note, the garage, be sure and have your car out of the garage today by 5 p.m. They are going to do some work on that, so please make sure your car is out of the garage by 5 p.m. Now I will yield to the lady from Grayson for a citation.
Chair recognizes the lady from Grayson.
Thank you. Would the secretary please report citation 78 with the clerk?
Mr. Clerk, please report.
Citation 78, Representative Heverin, Representative Bratcher, Representative Josh Calloway, Representative Griffey, and Representative Tate. Citation of adjournment. The House of Representatives of the Commonwealth of Kentucky does hereby adjourn this legislative day in loving memory and honor of Sergeant Benjamin N. Pennington.
Lady from Grayson.
Thank you, Mr. Speaker. Last week, whenever we found out the news about Sergeant Pennington, we shared a moment of silence on this House floor. It was a reminder that freedom doesn't come without a price, and that we are grateful for his service and dedication to the United States of America. We want to do this citation upon adjournment today, as he will be laid to rest at his home in Hardin County tomorrow. His body will arrive in Fort Knox this afternoon, and there will be a procession all the way to Glendale and to the final place at Central Hardin High School, where he was a graduate and where his funeral services will be tomorrow. I would like to thank the gentleman from Estill, the gentleman from Bourbon, and Mr. Mark Treadway for helping us fold the Kentucky flag to present to his family tomorrow on behalf of the Kentucky General Assembly, to show our gratefulness for his sacrifice that he made for each of us to be here today. I would like to yield to the gentleman from Bullitt 26 for a few words.
Chair recognizes the gentleman from Bullitt. Push your request to speak button, gentlemen.
Thank you, Mr. Speaker. Mr. Speaker, I want to first express my sincerest sympathy for the family of Sergeant Pennington. As an Army reservist and representative for the Fort Knox area, I've had the privilege to be surrounded by heroes in my life and represent a lot of heroes. Tomorrow in Hardin County, they lay one of those heroes to rest. When you join the Army, one of the things that you learn are the Army core values. And at the heart of those core values is one that always stuck out to me, is selfless service, putting this nation above yourself. For the last week or so, I've had the opportunity to read much about Sergeant Pennington, and he is a shining example of what this selfless service is. He lived the Army values, and he is a hero that we should never forget. Thank you, and I yield back to the lady.
Chair recognizes the lady from Grayson.
Thank you, Mr. Speaker. Can I please yield to the lady from Meade?
Chair recognizes the lady from Meade.
Thank you, lady from Grayson, and thank you, Mr. Speaker. Mr. Speaker, I ask that members of this body join me in a request before our Father as we come before him with grateful hearts, remembering the sacrifices made by those who have gone before us, especially today, Staff Sergeant Benjamin Noah Pennington. May we honor his courage and commitment, drawing strength from his legacy. Help us to live in a way that reflects our appreciation and inspire us to serve others selfishly, just as he did. May his courage inspire us to seek peace and justice.
And I ask that our Father helps us lift up the families of those who have served in the line of duty. Grant them strength, comfort, and peace as they navigate the challenges of separation and loss. Surround them with your love and support, and may they find solace in the sacrifices made by their loved ones. Bless them with resilience and hope now and always. And thank you, Mr. Speaker, and I yield back to the lady from Grayson.
Lady from Grayson.
And last but not least, I yield to the gentleman from Hardin 25.
Chair recognizes the gentleman from Hardin.
Mr. Speaker, today we pause to honor a true hero from our Commonwealth, Staff Sergeant Benjamin Pennington. Benjamin gave his life in the service to our nation, and his courage, dedication, and sacrifice remind us of the extraordinary price that we paid by those who defend our country. Today at 2 o'clock, our community will come together to pay tribute to Staff Sergeant Pennington as his remains arrive at Godman Army Airfield in Fort Knox. The streets will be lined by friends, neighbors, men and women, and children who knew him his whole life, as well as others who never met him. They will be holding flags, offering prayers, and sending Benjamin's family one clear message: he will not be forgotten. As we grieve his loss, let us also honor his life by holding close the values he fought to protect: courage, service, and love of country. May we never forget Staff Sergeant Pennington, and may his memory inspire us to live the same honor he exemplified every day. Though Benjamin was only 26, his bravery and commitment will leave a lasting mark on all who knew him and all of Kentucky. May we never forget Staff Sergeant Pennington, and may his memory inspire us to live the same honor that he exemplified every day. Rest in peace, comrade. I refer back to the lady from Grayson.
Lady from Grayson.
Thank you, Mr. Speaker. I'll end with continuing to ask this body to lift his family in prayer, his mom and dad, Tim and Carrie, and his sister, Mackenzie. Mr. Speaker, I would move for adoption.
Without objection, citation is adopted. Lady from Davis.
Mr. Speaker, that is all I have at this point in time.
Chair recognizes the gentleman from Clark 73.
Mr. Speaker, may I have the clerk report citation number 79 by title only?
Mr. Clerk, please report.
Citation 79, Representative Dotson. Citation of achievement. The House of Representatives of the Commonwealth of Kentucky hereby recognizes and honors the members and coaches of the George Rogers Clark High School Lady Cardinals basketball team.
Gentleman from...
Thank you, Mr. Speaker. Today I want to stand up here and recognize the phenomenal performance of the George Rogers Clark High School Lady Cardinals basketball team. Over the course of the 2025-26 season, the Lady Cardinals amassed an impressive season record of 33-2, captured top honors in both the 40th District and the 10th Region tournaments, and ultimately brought home the coveted state championship title for the first time in program history after overcoming a first-half deficit to defeat Assumption High School by a score of 48-43 and win the 2026 Clark Pump and Shop Girls Basketball Sweet 16 Tournament. Inasmuch as the members of the GRCHS girls basketball team, under the stellar leadership of head coach Robbie Graham and his exemplary staff, have demonstrated remarkable ability, perseverance, and skill, and have brought such tremendous honor and acclaim to our community and the Winchester and Clark County communities as we attained of such an extraordinary level of success and achievement, and today we want to honor them in this chamber. I move for adoption.
That objection, citation is adopted. There are 2 minutes remaining in motions, petitions, communications. Lady from Jefferson 38, I know you have a citation that is timely. We'll go ahead and do that one.
Thank you, Mr. Speaker. Would you ask the clerk to report citation 80 by title only?
Mr. Clerk, please report.
Citation 80, Representative Rourke and Representative Wilner. Citation of celebration. The House of Representatives of the Commonwealth of Kentucky hereby recognizes and honors the Iroquois Neighborhood Association in Louisville, Kentucky.
Lady from Jefferson.
Thank you, Mr. Speaker. The Iroquois Neighborhood Association has done something tremendous. They, in honor of Women's History Month and also just the good work that they do with historic preservation throughout the year, they have just chosen and put their efforts towards funding a memorial for Rosa Phillips Stonestreet. She was born and raised on her family's farm in South Louisville in an area now known as Kenwood Hill. After graduating from Nazareth Academy in 1887, she began developing her lifelong commitment to reformation and expansion of leadership roles for women. In 1882, she married her husband Charles T. Stonestreet and took his last name before his untimely death at age 35 in 1889. Following her husband's death, she began her career as a teacher at the age of 30. 8 years later, in 1897, the City and County Executive Committee nominated her for County School Superintendent, placing her against two male candidates. Stonestreet went on to defeat them, obtaining an unprecedented 56% of the vote. This marks the first and only time a woman was elected county school superintendent in Jefferson County, and it occurred roughly 20 years before the height of the women's suffrage movement. During her 12-year tenure as superintendent, Stonestreet fought to improve financial stability of the school system and advocated for dismantling the dysfunctional trustee system. Within the first few months of her term, she had sued the trustee of District 21 for obtaining money under false pretenses. She continued to push for accountability and successfully advocated for replacing political trustees with qualified professional educators. After persistent and determined efforts, she saw the Jefferson County School Board replace all trustees with legitimate educators. Stonestreet served as superintendent until 1910, leaving a lasting precedent on public education in Jefferson County. As her result of her trailblazing successes, Stonestreet Elementary School was erected in her honor, paying tribute to her hard work and activism for women in the workforce. And I'm sure, as you know, when we go to the Kentucky Fairgrounds, Phillips Lane is also named after her, as well as Stonestreet. With that, Mr. Speaker, I would like to yield to the lady from Jefferson 35, as she will acknowledge the work of the Iroquois Neighborhood Association.
Chair recognizes the lady from Jefferson 35.
Thank you, Mr. Speaker. There's a lot of South Louisville pride in what we're sharing with you here, and I'm really honored today to shout out the amazing Iroquois Neighborhood Association for their initiative to honor Rosa Phillips Stonestreet. Back in the fall of 2024, one of the association members attended a local historical league lecture about cemeteries in southwest Jefferson County at the southwest branch of the Louisville Free Public Library, and incidentally learned about the accomplishments of this unsung local hero who'd grown up nearby, learned that she was buried at Cave Hill Cemetery in Louisville, and that her grave had remained unmarked since her death in 1938. The board members of the Iroquois Neighborhood Association decided that 88 years was long enough for the grave of this very accomplished woman to remain unmarked, and they adopted a civic project to honor her grave with a suitable memorial. Once the project was adopted, they brought in some South End partners, including Shirley's Way, Little Loom House. They had a presence at the Iroquois Farmers Market and partnered as well with the Louisville Historical League to raise awareness and funds. I'm delighted to tell you that the tombstone has been designed, purchased, and placed, and that this Sunday during Women's History Month, there'll be a dedication ceremony at the gravesite. And I want to quickly recognize by name the 5 Iroquois Neighborhood Association board members. Suitably for Women's History Month, they are all women, and each of them could have a citation in their honor for all of their incredible accomplishments. Association President Susie Wessel, Vice President Vicki Welch, Secretary Stephanie Sidnor, Treasurer Stephanie Buzan, and Director Barbara Nichols. I'm so grateful to these women for their role in preserving South Louisville history, not only through this project, but for their previous work on the research and installation of 9 historic highway markers throughout South Louisville. With that, the lady from East Iroquois yields back to the lady from West Iroquois.
Lady from Jefferson.
Thank you, Mr. Speaker, and thank you, lady from Jefferson. I move adoption.
Without objection, citation is adopted. We have one more that is for a funeral tomorrow, so lady from Scott, I will allow you to go, and that is the last citation for today. And then if any chairmen have announcements, I'm going to clear the board. Please push your request to speak. We'll get your announcements done. Lady from Scott.
Thank you, Mr. Speaker. Would you please have the clerk report citation number 83 by title only?
Mr. Clerk, please report.
Citation 83, Representative Grossel. Citation of adjournment. The House of Representatives of the Commonwealth of Kentucky does hereby adjourn this legislative day in loving memory and honor of Nick Baker.
Lady from Scott.
Thank you, Mr. Speaker. Kentucky lost a highly regarded citizen, statesman, and public servant a man of tremendous integrity and vision last Friday with the passing of former Kentucky State Senator Nick Baker. Senator Baker was a Perry County native who was elected to serve as a member of the Kentucky State Senate in 1969 and represented Senate District 38 from 1970 until 1978. During his tenure, he earned a commendable reputation as an outspoken advocate for equal funding for women's sports. As a member of the Senate, his crowning achievement was Senate Bill 73, requiring that any school that received state funds and maintained a men's basketball team would also need to establish and maintain a women's basketball team. This historic legislation changed the lives of countless promising young female athletes and opened doors for those who might not otherwise have been able to afford post-secondary education. I never had the pleasure of meeting Mr. Baker. However, I'm blessed to count his precious son, Hank, among my friends. Like his father, Hank has been called to service. He represents America's interests abroad in the U.S. Foreign Service. I ask that members of this body join me in expressing heartfelt condolences to the Baker family, friends, and all who share in the loss of this esteemed senator, veteran, attorney, and man of faith for the many generous contributions he made to his family, his community, his church, and our Commonwealth as a whole. Nick Baker will be profoundly missed by all those whose lives were touched and made better by his presence. Mr. Speaker, I move for adoption.
Without objection, citation is adopted. Chair recognizes the gentleman from Johnson, 97.
Thank you, Mr. Speaker. Communicate with the body.
May proceed.
Thank you, Mr. Speaker. BMAP will meet Tuesday morning at 9 o'clock, room 169. Thank you.
Members take note. Next order of business is introduction of new resolutions. Mr. Clerk, please report.
House Concurrent Resolution 125, Representative Lehman, a concurrent resolution establishing the Kentucky Riverport Modernization Task Force.
Lady from Davis.
Yes, Mr. Speaker, there's a couple more announcements of committees, so I don't know if we need to go back into motions for them to make those announcements.
Go ahead and make those from the floor before we go into the next order. You may proceed.
I yield to the gentleman from Fleming, Carter.
Gentleman from Carter.
Permission to make an announcement to the body.
May proceed.
House Local Government will meet at 9 a.m. on Tuesday.
Members take note. You got another one, gentlemen? Lady from Davis.
Mr. Speaker, I move that the House be in recess for the meeting of the Committee on Committees and the Rules Committee at the Clerk's desk.
Motion made that the House be in recess for meeting Committee on Committees and Rules Committee at the Clerk's desk. Without objection, so ordered.
House come to order. Next order of business, the report of Committee on Committees and the Rules Committee. Clerk, please report.
The Committee on Committees has met and referred the following bills and resolutions: to the Judiciary, Senate Bill 195; to Post-Secondary Education, Senate Concurrent Resolution 66, Senate Joint Resolution 116; to Veterans, Military Affairs, and Public Protection, Senate Bill 77, and Senate Bills 102 and 278. The Rules Committee has met and posted the following bills and resolutions to the regular orders for Tuesday, March 24th, 2026. House Bills 283, 583, 732. House Concurrent Resolutions 107 and 110. House Joint Resolution 110. Senate Bills 17, 22, 29, 49, 65, 100, 110, 116, 124, 137, 158, 219, and 222. The Rules Committee has met and recommitted to Appropriations and Revenue, Senate Bill 8.
Thank you, Mr. Clerk. Next order of business is introduction of floor amendments. Please report.
House Floor Amendment 2 to Senate Bill 8, Representative Miles. House Floor Amendment 3 to Senate Bill 101, Representative All. House Floor Amendment 4 to Senate Bill 101, Representative Wilner. House Floor Amendment 1 to Senate Bill 129, Representative Massaroni. House Floor Amendment 1 to House Bill 283, Representative Roberts. And House Floor Amendment 1 to House Bill 885, Representative Gordon.
Thank you, Mr. Clerk. Next order of business is adjournment. Lady from Davis.
Mr. Speaker, I move that the House stand adjourned until 2 p.m. Tuesday, March 24th, the year of our Lord, 2026.
Without objection, the House shall stand adjourned until 4 p.m. Tuesday, March 24th, the year of our Lord, 2026.